When you walk into the front of the building, you come to our main door, and I really like this door. It is so classy. This is our lobby, and we share it with our neighbors, of course. So there's a great big screen right there. One day I'm going to actually start using that to broadcast what's being recorded in the studio. So if you're sitting in the lobby, you can see what's going on in the studio. And you walk in, here's my neighbors. Got some great neighbors. There's the powder room and restroom right there. But right behind you, as you turn around, is Podium Studios. So let's go check it out. Let's see what's going on in there. And when you walk in, you immediately see the control center, the producer's desk. You see right there, we have another big screen. You can play videos as well as use it as a monitor. We use it as a monitor sometimes. Here's our producer's station, producer's desk. Usually come in and turn on the computer and get the day started. You see we have a Mac Studio M3 as well as the Elgato Stream Deck. We have 3 cameras. That big monitor right there is the producer's monitor, but have no fear because on the other side is another monitor for our guests. Here, of course, are 3 angled cameras. This is our confidence monitor or monitor for our guests. You can use it as a teleprompter, another video screen. And here at the desk, the infamous table, are 4 mics, 4 chairs. We have a great set of lights. I'll show you how those lights work in a moment. And of course, the big screen in the back. We can put whatever it is that your content on that screen back there. And here we have our Rodecaster. We control all the audio there. We have our ATEM Mini that we use to switch between different camera angles. I need to actually turn on the cameras real quick, so let's check that out. Usually when we first walk in every morning, we do these things, turn on everything to make sure everything is working properly. And now we are ready to go. This guy right here decided he did not want to come on. He had a long weekend, I guess. I don't know. And we sit on down at the producer's station. You can see this is where the producer's angle is. And now our ATEM is on, so we're turning it. You can switch the different camera angles, and a producer can see what he's recording. Now, the neat thing is on the confidence monitor on the other side, the guests can also see what the producer is recording. So they'll see who's being focused on when. So it gives them an opportunity to know what they're supposed to be doing. And that is our sign. Our sign is back. And really proud of that thing. It looks fantastic. And you'll get another chance to check it out in a moment. So, of course, we have 2 main lights and a hair light. And let's turn the lights out and kind of get a feel for it. And turn on our on-air sign for the ambiance. So now you can see here, this is what the guests could see if we wanted them to be able to see themselves, so they can make sure they're paying attention, make sure their face is right, or make sure they're close enough to their mic, anything like that. It's just another way to give them an awareness of what's going on. And that's me. So, of course, we do have 4 microphones, and each microphone has its own set of headphones, as well as a power strip in the middle for your laptop or any kind of equipment that you might have or you might need. We also use a tablet. This is our iPad. We use that when we're recording for ourselves so that I can control it from there. This is the side studio, and this has always been under development. So it's still under development. I'm going to get it done. I promise. And I want to be able to have 2 guests be able to sit here with one another and face one another. And so sourcing the right kind of chairs has been a little bit of a challenge. And keeping this room from becoming a stopgap has also been a challenge. But so far, I feel really good about it. The sound in there is pretty good. And I think it'll be red. The lights, the cameras, and the chairs. It'll really look nice. So one thing, we have lights in here that weren't turned on yet. So let me get those plugged in for you real quick. All right. So right now they're blue, and we're going to go real quick, and I'm going to show you just how I manage all the lights, because we can change the lights to whatever color that fits your scheme, whatever fits your ideas, whatever like that. And so this is how it would look from the back of the house, of course. And right here, I have an older phone that I've connected all the lights to, and I'm able to take that phone, plug in, tap in they're grouped. So the main house lights, the main studio are grouped, and the side studio are grouped. All right. So now you'll be able to see, notice they were blue. Now they're purplish. So I can change it to whatever color I want. So just use that. This is a side studio. I want them to be green. Bang. Now they're green. So go back over here to the main studio. I can do the exact same thing. Want them to be a different color. Your wish is my command. Different color it is. So you want them pink, you want them yellow, whatever your color scheme is. Works out fantastic. Very responsive. And feel good about those. I really like the way that came out. This app was fantastic. It's really a great tool to add to that, because it really helps change, and everybody's feel and vibe might be different. So whatever it is that you're trying to convey, we can let those lights help you out a lot. I'm kind of biased to green, as you all have kind of probably picked up. But so that's those little lights right there. Again, that's what they do. Now, we also have, one of the things I want to point out, like I said before, is each microphone has its own special set of headphones. And we have the over-ear kind as well as the in-ear monitor style that like musicians use in concerts and whatnot. So that's a great thing that we have. And then the very last thing is all of the lights in the building or in the studio are connected to a Google Home. So I can just tell the Google to turn off the lights, and it'll turn off all the lights. Or I can tell them to turn off the whole studio, and it'll turn off everything in the studio. So when I say, Google, turn on the lights, it turns on the lights. And I say, okay, Google, turn off the lights. It'll turn off the lights. But the podium sign is connected differently. So we gave that one its own special indicator. So that way that can stay on if we wanted it to stay on, to create some kind of ambiance or whatever like that. And you may have noticed that the lights under the table did not go off. And you also notice the lights under the table are their own color. The lights under the table are a different brand, so we weren't able to get them connected to the same light source that we're using for the side and the main studio. We'll get those changed eventually. So that's how that works. The side studio, hopefully next time I'll show you something new there, that we've made some changes. And there's our podium sign. Again, super proud of that. It looks fantastic. Let's go ahead and go back out into the hallway and wrap up this tour. So I really like this lobby. I keep saying that, but I mean it a lot. This is a fantastic look, and it really sets a nice tone. It's super comfortable. So when we have a lot of guests, they can just sit out here, relax, work on work and whatnot, and everybody's in a good to come in and do their actual recording. Our neighbors are super responsive and kind, so it works out very well. This is a great place. I'm glad you're able to do this. Grace and peace, everybody. We're back. So you saw the thumbnail, you saw the title. We have no idea what we're going to do today. So this is day 115 of the YSL trial, and it's been wild. It has been totally wild. So I thank you all, everybody that's already tapped in. Thank you so much for clicking the like button, jumping in, saying hello, being a part of the best live stream on the planet and the best live chat in the solar system. I really do appreciate it. And and I just wanted to give you guys another peek at the studio. I'm going to be going to do a new, I'm going to do a new tour of it probably tonight or maybe this week, because we've made some changes. So I think some pleasant changes. So I think some things will look a little bit better. And then also people have asked, I need to do a tour of my actual studio that I've been sitting in right here. So we'll do that soon enough, and I'll make sure that's available to y'all. I already saw the question. Hey, I think this is a great question right here. What's silly and crazy is going to happen today? I have no idea. Let's just tell the truth. I have no idea. But I would never have expected Doug Weinstein got a burr in his saddle yesterday. I dropped that video of Doug Weinstein, calling the judge to like, hey, I want to argue this motion. I want to argue about the fact that you need to rein this in. You should not just allow the state to just run amok. And I have to admit, don't tell anybody this, I didn't realize that the state doesn't run the court. I actually thought they did. Now, I admit also, this is my first time really diving into a full-on court case. I didn't realize that the state doesn't have the ability to just go forever. I really thought that's what they were supposed to do. I was thinking like, oh, they're supposed to just go on forever. I just thought that was the way they went. So Doug, dropped some knowledge on me. I learned that for sure. However, I also want to say, I didn't expect him to get that snippy with her. And let's also say, I didn't expect Judge Whitaker to push back on Adrian Love so much. She did push back a little bit with that whole pill passing and finding the shank. Remember when she said, was the shank inscribed with the initials YSL on it? That was some high level snark right there. But I got to say it again. This is Judge Whitaker's fault, though. She should have been telling them to move this along, get it going. So I have no idea what's going to happen today. That's going to definitely be we are all going to be waiting with bated breath to see what actually happens for sure. Good to see everybody. Real quick, I just want to say thank you to everyone who's already tapped in. Thank you so much, Felicia, for stopping by. There she is, the lovely Miss Mandy in the building. Thank you so very much for stopping by. Gordon as well. Paris is up in here. Good to see you. Meme Sweet Tea. Good to see you. Oh, wow. We have a great setup. Well, thank you. Dennis, what's happening? What time? Court is supposed to start at 12:30. So I wanted to check the sound, make sure everything worked right. I do want to talk a little bit about the DNC. So we're going to jump over into Twitter and kind of just go over some highlights or lowlights, however you determine it, about the DNC. I'm just going to tell you the absolute truth. I'm going to tell you the absolute truth, y'all. I'm trying not to lie to y'all. Number one, I got a strike on every one of my videos from the RNC. A strike on every last, not a strike, but a takedown request from every one of my videos I did on the RNC. So remember we did that long watch party, watched all the video and stuff like that, all the speeches and stuff. I had kind of intended to do that for the DNC. However, once I got a strike literally for everything I put up, all those long form videos, I got a ding, if you will, on YouTube. It doesn't count against me and not demonetized, but it's just a hassle. And you're like, I just don't like seeing it. That was one reason why I said, I don't know if I'm going to do that. But then also, I'm just going to be honest with you. A lot of the stuff that they're talking about doesn't resonate with me as a Christian man. So I don't agree with the lion's share of their positioning. And so it was going to be hard for me to watch it and not turn it into just a commentary. So I said, I'll just go over a couple of snippets rather than watch the whole thing. Because I promise you, I would have been ranting the whole night. So the little snippets I saw already had me ranting. So I can only imagine if I watched 3-4 hours of it, I would have been insane. So that's why. But what's going on? Thank you, Fendi, Miss Fendi. Good to see you. Carolyn's up in here. She says, good morning, DWC and the chat. There he goes, all the way from Germany. Alan is in the building. Man, sir, thank you so much for tapping in. And by the way, shout out where you're from. Just real quick in the chat, where are you from? Y'all know I'm here in the great Peach State. If you got a emoji that kind of represents or a flag, feel free to do that as well. But where are you from? Shout out to Alan, all the way in Germany, across the pond, down the street, across the pond a little bit. Just listen to Brian Still argue. It was so interesting. I totally forgot about that. Please forgive me. I started doing some chores around the house, and then I said, let me get this video started a little early, check on the mic, and I forgot. If you have a link of it, we can maybe watch it later during lunch, or maybe I'll do that first thing in the morning. So if you could, Whitney Mask, if you have it, send it to me to help a brother out. Let's see what we got. Kim in the building. She says hello to everybody. Good to see you, dear World Christian fellow HBCU alum. What's going on, Kels? New subscriber. Thank you so much. I'm glad that you dig the channel. Where are you from? Come on. Tell us where you're from. What school is it? What school? The school must be named. It must be. Love to hear it. Thank you so much, Transplanted Texan. Yeah, drop the link if you don't mind, Whitney, or you can shoot it to me in email and I can upload it. Hey, what's happening? Yesterday was wild. So not like wild. It was definitely more entertaining than I had anticipated. Let's say it like that. What's his name? Little Rod's attorney. I think her name is Leah Bassey, I believe it is. Please forgive me. I know her first name is Leah. I loved the way she was arguing yesterday. Then we had Miss Westmoreland gave a little bit in there as well. We watched. Okay, this is something else before we talk about the RNC and the DNC and jump over here to Twitter. Something I noticed, and I'm not trying to be mean to Adrian. I don't think Adrian Love writes out anything that she says. I don't think she, if anybody knows me, they know I have these little books on my desktop and I'm always writing notes. I'm always jotting down what I want to say in a video. And then I literally transcribe it into an actual script. Now, I may or may not use that script, but at least I've gotten all of the ideas out of my head. When I was a second grade teacher and chief executive secondborn was also in second grade, and even when President Firstborn was in second grade, I was still a second grade teacher. I would actually teach some of my lessons to them as second graders. They didn't go to my school, but I just taught them and just to see what they thought. Like, oh, does that make sense to you? Is that clear? So on and so forth. And the reason I bring all that up is because there's entirely too many instances where Adrian Love is caught and wait, put a pin in it. One of the things that you do as a teacher, you pick a student that you know you're teaching to. Usually it's the middle of the row student, or it's a lower tier student, and you're teaching to that student. And everybody above them, you're trying to push them up, and anybody below that student, you're trying to pull them up to at least the middle, or at least to that the model student, okay? So you're trying to anticipate, okay, little Johnny right here, little Sally right here. What is there going to be their problem? What's going to be their questions that they ask? What are some ways that they're not going to understand? Or what are they going to do that's going to throw me off? That's what you're focusing on, that student. And you're always trying to make sure that your questions, even when you're asking questions or answering questions, you're hitting the top tier students. You're giving them more to think about. But then also those lower tier students, you're trying to push them up, so on and so forth. I bring that up because Adrian Love, I don't think she ever thinks about some of the questions that Judge Whitaker could ask. She has the data, she has the things in front of her, but she's never thought about how is she going to present this stuff. She hasn't considered, in my opinion, how is, for example, she's teaching toward Judge Whitaker, okay? And these other people in the defense are her opposition, dare I say, the ones that are trying to throw her off. So she's never taken the time to say, okay, if I'm presenting this and Brian Steele throws an objection, if I'm explaining this and Doug Weinstein falls out of his chair, if I'm nothing of that nature, I don't think she's thought about it. So therefore, she never comes across confident. She never comes across like she's thought about what she's saying. And you contrast that to like Leah, the young lady that was that did argue against using new crimes to bolster the indictment. It was crazy. What's it called? Intrinsic acts. And she skewered her. You could tell clearly that Leah had thought about what it was that she was going to present. However she did it. I don't know if she talked about it in the mirror, if she did like a mock trial, but you could tell clearly that she's thought about it. Adrian Love was caught with her shoes off. She was caught totally off balance. That's when she starts, what did y'all say? She's uploading, she's buffering. All that stuff happens because she's never actually taken the time to think about what she's going to talk about, consider possible objections, consider possible pushbacks. And that's why I said, I really think they should turn this into debate style, like literal debate. You got 2 minutes, a minute, 3 minutes. I mean, they should do debate style because I think it would help her. Just my little observation. Shout out to Adrian Love. Am I being awesome? Well, thank you so much, Jazzy. I appreciate it. Thank you so much. Oh, Lord knows. Y'all know transplanted Texan she is a hostage. Transplanted Texan is a hostage anywhere that's not Texas. Okay, that we know. Michael said he in the old 4th Ward. Are you here in Atlanta? Shout out. There we go. Cincinnati, Ohio. Alabama. Okay. I thought you were Andre. I thought you were another one of those transplanted people. Transplanted Texans going to let us know at every turn that they are transplanted. They are hostages away from Texas, the great state. Detroit checking in though. All right. Love it. Thank you. Iowa up in here. Seymour, Connecticut. I've never seen any of Connecticut. There we go. What's going on, Kels? Phoenix by way of Cincinnati. I love it. What HBCU did you go to, Kels, by the way? Arizona up in here, and as well as North Carolina. All the way from way up north. North Georgia, that is. Tennessee up in the building. Good to see you. Justice Flies here in Georgia. Checking in. Good to see you. What's happening? Let me do this also. While I'm sitting here talking, I need to make sure I have the video ready. So when they get ready to go. Even though the prosecution yesterday decided to phone it in. That's so crazy, man. I mean, to their defense, because I'm trying to be an even deal, I'm trying to be a fair guy. It seems like they just got the time mixed up. I don't think that's a good excuse. I don't think that it's the right thing to run on. Like, oh, the dog ate my alarm clock. That's not acceptable. However, it seemed like they were all unified in their error. So that's just it. Let's see what we got. Pink is up in here. Good to see you, Pink. Thank you so much for stopping by. Always present, but not perfect. Is here. Thank you so much. Oh, the link is on Thugger Daily's page. I will be checking it out momentarily. Well, how long is it? I wonder. Maybe we could check it out here because Thugger is my guy. Thugger, Black Law Student, all of them. Let's see. I see the motion. I don't see the video though. Let me see real quick. Is it? I'm scrolling through to see the video. I don't see it, but yeah, the young lady's name is Leah Abbasi. Okay, that's who it was yesterday. I'll find it though. Don't worry. Fisk in the building. I had some good friends that went to Fisk. All right. I will absolutely keep you. Absolutely. All right. What does K-Way say? K-Way says, do y'all think the judge is prejudiced and thinks that ignorant act that she sees on video or photo shows gang activity? Because it seems like Love knows that and is playing on it. Okay. I try to give solid answers and then explain them. No, I don't think she's prejudiced. I think she just doesn't know. Because a lot of that gang stuff on there, I didn't know what was going on either. I'm going to be 100% honest with you. I didn't know a lot of stuff either. So I do believe, however, Adrian Love is trying to define things like, oh, so-and-so's doing this with their shirt. That's gang activity. Oh, look, Jason's shoe isn't tied. That's gang activity. No. I don't think she should not give her that much latitude. But that's just my little 2 cents. But I don't think it's on Judge Whitaker. I do think that this is part of the issue of this trial is there's so many levels and layers of just weirdness and complexity. Because, I mean, we're not talking about, I mean, I live here in Atlanta. We're not New York. We're not a California city. We're not a city. Now, do we have gang activity? Absolutely. Is there, I'm not saying that we're country bumpkins by any means, but we're not Chicago. Okay. So we're not familiar with a lot of this. So it would be complex and it would be different to try to explain or expect one to be abreast of gang activity. And you got to, the only one that knows it is the prosecution. So I don't think it's on Judge Whitaker in that regard. I think it is on Adrian to make it clear. And I think she should ask better questions. Judge Whitaker should. Thank you so much, Amy, up in here. What's happening? From the UK, Valerie. I'm loving y'all tapping in from overseas and abroad. Thank you so much for stopping through and just hollering at your boy. I appreciate it. Thank you so much, Foster. Always good to see you up in here. Erica's up in here saying, what's going on? Oh, we just getting warmed up. I want to make sure the mic works. I want to make sure we got all the visuals, all that kind of good jazz. So you actually have missed nothing. You are up in here. You are tapped in and you are up to speed. I'll start a little later. So we'll be checking that out as well. What do we have here? Well, thank you so much, David. I appreciate you being a part of the chat. I appreciate it. Lots of good people back and forth. Pamela up in here. I love it. Thank y'all so much. If I missed anybody, I did not miss Monica. I see her. Love doesn't take notes for discovery reasons, in my opinion. Love doesn't take notes for discovery reasons. Okay, I can give you that. I can give you that. What I meant by notes is like sometimes she'll have like very oft times the defense, they bolster their case with law, case law. Was it Brown or this ruling or whatever like that? Most of the time, Adrian tries to bolster her case with words and just persona. I promise you, as sure as my name is Jason, I don't want to say exudes bulliness, but I guarantee you, she gets her way a lot. Just by her presence, her physical body presence, she probably gets her way a lot. And she don't have to feel like I ain't got to answer to you. I am. I guarantee you that's what she be doing. So here, I'm just going to say it again. She would benefit significantly from teaching elementary school for 6 months. I bet you 6 months of teaching elementary school, and I mean the whole gambit. Nobody in there to rescue you. No calling the admin. You are Miss Love from, August to February. That's not 6 months, but you get my point. I think it would help her because it would help her with her planning, help her with thinking on her feet, help her to get ideas out in a clear and concise manner and not being so super verbose. Some of the word, just say yes. Just say yes. You did not need to write a paper to say the word yes. Just stop it. But I think you're probably more right than wrong. Absolutely. I think this is, yeah, and Eric, I literally was telling somebody this morning, I do believe that they just want to win by any means necessary. And that's, in my opinion, is the flaw of this case, because they're nose blind to the fact that this case stinks to the high heavens. There are so many glaring errors, but you just got to win. You're going to win. You're going to hook or crook. You're going to drag this carcass across the finish line at the Kentucky Derby, but you're going to win this case. But ma'am, you're still going to get this. You're still going to lose. And it doesn't look good. We got people tapping in from around the world watching this case, and they're watching you. You are the face of this case. And people, I'm sorry, lots of people, this is not, again, people had to be introduced to various and sundry senators when they were in their particular states. If Adrian decides to run for any kind of political office, or Adrian decides to get involved in anything outside of Georgia, bigger than Georgia, everybody's going to be pointing back to this. Like, this is your interview. This is your highlight reel. Take a second and just think about that, Adrian. This is your highlight reel. This is what you want people to remember you by. So if you want to run and be state AG of Georgia, or, whatever role outside of Georgia, they're going to be looking at this. If you decide to run for DA of Fulton County or DA of somewhere else, good gracious, stay out of Cobb County. We're going to be looking at this. This is your highlight reel. This is your resume. You don't have to send a resume. We'll just look at this. We got 115 days of you basically interviewing for whatever position role that you're going to go to next. That should cause you to think. She's never, and the fact that people always say you're never prepared, I mean, that's not a good look. And I do think it's funny that Glanville at one time admonished Brian Steele as being unprofessional and unprepared. And I don't know, and I might have to go back and do a little quick search. Had he ever said that about the state? Because, Brian Steele was shall we say, he was fit to be tied about that whole, because he said this in front of the jury. I think he was wrong for saying it, but I just wonder, had he ever said anything akin to that to the state? Because, I mean, my goodness, in the morning, had they ever come in late like that before? They're always unprepared. So that was very interesting. What's Carolyn say? Speaks. Prosecution is in it for the win, not justice. Guilty until proven innocent. Come on. And even in that, I fear the proven innocent that's going to have an asterisk next to it too. It's going to be written in pencil. They're going to find another way because they just want this gentleman in jail. Good to see you, JC. Thank you so much. I appreciate the comments on Twitter. Thank you so much. Good morning. Hey, we're over here rocking it out over here, Bridget. Thank you so much. And all right, let me see real quick. So are y'all watching all right, not turn this into a long debate or discussion like that. Are y'all watching the DNC? And then what are your thoughts on it? I see lots of people tapping in, but what are your thoughts on the DNC? Are you feeling encouraged? Are you super energized? Are you like, no, this is not what we're about? What are your thoughts on the DNC? They started yesterday. I'm originally from up north, so I was a little bit interested in it, but I just said it just isn't my jam. So most people are saying no, nope. Okay, yes, okay. I appreciate it. I missed last night. Okay. Oh, wait. Didn't he tell Love that prior preparation prevents poor performance at one time? I thought Glanville directed that at the DA table. If he did, and he may have retired. So what I'm talking about is him pointing his finger at retired and saying, retired, you are out of line. You are unprofessional and you're unprepared and you need to get your stuff together. Because that's what he said to Brian Steele. I want to see, did he get that same smoke to Love and Hilton and Atkins? They had some other people earlier on as well. I just like, where's that same energy for them? Now, if he did that to them, then that's what I'm looking for. But he gave Brian Steele like fits. So that's what I was looking for though. Said, I missed last night. It's trash. Watching for a good laugh. Okay. Didn't watch either convention. Okay. I'm in Indiana and no. Okay. This is what I was getting from it as well, Greg. Greg, you and I, man, we might be brothers from another. The energy level was just not there. The clips that I watched, some people were sending them to me. And of course they're on Twitter. I was like, I didn't get that same excitement, exuberance that you saw in other, during the DNC, the RNC. Sorry about that. Oh, they did send it to me. Oh, how long did Brian Steele speak? Oh, it's 2 hours long. Oh, yeah. Okay. We're gonna have to start. Okay, somebody just sent me the Brian Steele. Oh no, it's not all that. No, it's not super long. Okay, I'm sorry. I'm looking real quick. It's not as long as I thought it was, but it is. It does. I do need to find where it is. Okay, so we might do that during a break, or I might do it start tomorrow. Okay, but Brian Steele, if you're wondering, the reason court is starting late today is because Brian Steele is pleading a case before the Georgia Supreme Court. And someone sent me the link to it so that we can actually see it. But I just got it. So I'm trying to do that, multitask. And my students will tell you that I wasn't the best at that. All right. So she enjoyed it herself. Thank you, Pink. Couldn't stomach it. Okay. It was entertaining. Okay. Yeah, I didn't. And this is something I've said this. And if you follow me, I've said this about Trump as well. By the way, I think they might have heard me because they've definitely made some adjustments. I think we should focus on not on personality, but policy. Because at the end of the day, I might not like the way you say something. At the end of the day, I might not like your cackle or that you only wear pantsuits or whatever. But your policies are what ultimately are going to impact me and my family and the things that I'm concerned about. So that's what I've been asking people, like, what are the policies? And I'm not getting a lot of that. So it's interesting. I'm watching it. K-Way says I'm watching it. Not as entertaining, but I can get with some of the policies they are running on. Okay. Oh, y'all said Kamala is as prepared as love. That is hilarious. That is hilarious. What does Brittany say? Brittany, good to see you. That was when he excluded the PowerPoint, but the jury wasn't present. Oh, you're talking about the preparedness. I do remember the PowerPoint. So if that was it, yeah, I don't see where Glanville gave the same type of level of antagonization and just opposition to the state as he did on a regular basis to the defense. Because y'all do remember and I found a video. I'm sorry. I found a video of the gentleman who had to write the paper. Remember Glanville made him write a paper, 17-page paper about preparedness and tardiness. Like what? But they got a pass. The whole team was absent yesterday. They got a pass. But and that dude was late, I want to say 17 minutes. They missed 30 minutes in the building. So yeah, those are the kind of things. Oh, what does James say? James says, I am hoping that Kamala will say she's dripping, or rather, I think he said dropping Waltz for his lies and stolen valor, then announces Harris Willis ticket so I can cover my Harris Willis square on my 2024 bingo card. That would be bonkers, okay? Jazzy says, I am in Alaska, which just seems like such a picturesque place. We have another fantastic commenter in the chat that lives in Alaska. She sent me some beautiful pictures of Alaska. I've never wrapped my mind around that. I've always thought Alaska was like 25 inches of snow and frozen. Go figure. But you know what, though? Fun fact. I didn't think that people lived in Las Vegas for years. I mean, I was well into college and I met somebody who was from Las Vegas. I said, wait, what do you mean? It was the craziest things that you never think about. There's like a school district and people live in Las Vegas. All you think about is the Vegas Strip. And I had never thought about it until I met that person. I was like, I've never thought about this. Biden announced like 5 hoaxes that have been proven wrong. I'm not surprised. As one who viewed Atlanta as the Black Mecca in the 90s, guilty as charged, I'm appalled at how professional Black women are so hell-bent on sending young Black men to prison by hook or by crook. It's sad, shaking my head. That right there needs to be a t-shirt because it's a very real reality. I agree. But I've said that about this case specifically. What's going on, Carolyn? I said, no, she's not doing that. No, not doing that. I can't listen to her laugh. I agree with that as well. You missed it, okay? So Biden did speak. I did not actually see Biden's speech. That's interesting. Let me just real quick. I mean, and the protest, my goodness. Now that's something I definitely did not expect. the amount of protests that have been going on in Chicago has been pretty wild. But I think they're going to probably make it out unscathed. I think at the end of the day, it'll go off without a lot of drama, which will be good because Chicago, like, listen to their mayor was embarrassing. Like, y'all got to be kidding me. This is your mayor talking this trash? Like, man. All right, what we got here? No policies given. Doug says, please forgive me. You like the purple logo. Oh, you're on the other channel. Well, I'm glad you like the purple one. Yeah, I'm not keen on that. I'm gonna take a pass on that, Jazzy. I'm with you 100%. What's going on, Rebecca Starr from the city of Roses, Portland, Oregon? Really? I didn't know you're from Portland. Man, Portland was such a beautiful town. I don't know how it's doing now. Good to see everybody who's tapped in. Let's go ahead and make sure that the case has not started. They have not turned on the cameras yet. Making sure they're not tricking your boy. They like to throw a little Mickey Flynn on me every now and then. All right, so at the current moment, we don't have any. Okay. But they say it's going to start at 12. Oh, hold on, let me bring this in. On their end, it says 12 o'clock, but I thought Judge said they were starting at 12:30. Let me double check and make sure I don't miss that. Somebody going to tell me. Somebody going to text me in a minute and say, Jason, you're missing it. All right, let's see. I got a chief executive, second born, just text me, asked me to pick her up from school today. All right, let's just see. All right, 12 o'clock right there. So I'm just going to leave this up here. I'll just have it ready so we can be ready to rock and roll. Early. That'd be great. All right, let's see what we got here. Yeah, somebody saying 12:30. That's what I thought yesterday as well, because she was joking with the state who can't seem to show up on time. She said 12:30. I thought so, but over here it says on Law and Crime, it says 12:30. I just want to make sure that it says 12. So I just want to make sure I'm there and ready to go just in case something pops off soon, which I'm not expecting much. I do hope that she allows Doug Weinstein to argue his case for a speedy trial. I think that would be very interesting. Allow him to kind of get that off his chest, so to speak, and get that out. And because she was a little bit tart with him about it, as if I'm finding it really weird how the state as well as the court have been able to say that it's the defense's fault that things are moving in the pace and the speed that they're going at. That's been wild. Like, how are y'all able to do that when you're literally, this is your case? You have the ability to do that. So I think Doug did a fantastic job. If you didn't read that motion that Doug wrote, it was really good. I really have to admit, I was very impressed with it. And he makes it very clear, like, the reason this is taking so long is because they're bringing in four gang witnesses that are basically all saying the same thing, or they're unprepared, and they're all, I mean, the things that we've talked about, a lot of things that we've picked up here on this channel and other channels, he brought them to the forefront. And I really hope that, I hate that kind of stifled him from being able to argue that and kind of tease it out a little bit, because I think it would have been good for that to happen. And that is what the judge might have said, but I got what you did there. Yeah, it's 12:30. Lake Oswego, Oregon, in the early 80s. Portland is no longer the jewel it once was. I think that is interesting that they chose Chicago, because Chicago politics is, it's a different kind of game, for sure. So, I mean, the fact that if you look a little bit south of Chicago to Dalton and realize that Tiffany Henyard is the mayor of the village of Dalton and the township supervisor of that region, if you will, and just the havoc that she's running, and just running amok. And the fact that the attorney general has not done anything, the fact that the governor hasn't done anything is just amazing to me, because it's just that wild. It is. All right, what we got here. Biden did it good for being 81 and fighting cancer. He got through it and passed the torch on. Really? Okay. So he has, I didn't know he had cancer. I'm sorry to hear that, sir. I didn't know that. Okay. She was very weird with Weinstein. Thank you, Karen. I think, again, it's hard to not, even Brian Steele commented on, let me see real quick, find that. He literally commented about some of the things that Judge Whitaker has said. Let me remove this out of the stage. There we go. And I just thought it was really wild that he commented about it, that when Adrian Love was talking about why the case is taking so long, and Adrian Love was talking about why the case is taking so long, and Judge Whitaker kind of adds this caveat, like one of the reasons that the case is taking so long, like this is Brian Steele. Like Brian Steele is, and this is not the comment I want to point out, but I do want to point out. Let's see, what is he saying here? All right, so this is on JC. Shout out to JC is in the chat. All right, let me make this a little bit bigger. That's a little bit better. All right. Doug having to sneak in an argument on his most recent motion. Because again, she wasn't going to say anything. I thought that was super weird that she was just kind of let it slide. But watch this. Whitaker didn't even want to allow that. It's so clear that these Fulton County judges want the outcome of the trial to be granted, but not granted. And shouted out Doug and shouted out myself. Notice right here. I thought this was interesting that, hopefully I'm doing this right. I mean, Brian is clearly perturbed, I think is a good word, because he mentions that she's bringing up the audio as if the audio was the reason why court has gone so long. Hold on, where is it? I'm terrible with this. But anyway, this is Brian, what Brian said. Brian Steele, shout out. I commend Doug Weinstein for his efforts to ensure the judiciary is held to account. There are major concerns about the transparency and fairness of these proceedings. It appears that the judicial officer, judge, attempted to downplay the ongoing unethical behavior patterns of conduct. There are allegations of ethical standards have been breached without consequences. And look, he literally puts hashtag nasty work. I mean, Brian Steele is not playing. This is amazing. Let me see. I want to pull up this other one. Hold on one second while I'm talking. I just thought that was interesting. That, I mean, you can see that they're frustrated with Judge Whitaker and what's going on. Dog, I can't find it. But Brian was literally talking about how, oh, here, I found it. Praise God. All right. I have no idea where this was. Okay. So this part of, okay. So JC again, shout out to JC in the chat. All right. Here comes Love's lies and Whitaker excuses. All right. And right here, let's play this real quick. Let's pull like this.
I know at this stage,
One in the chat if you can hear.
I've only after witness saying the same thing, exhibit after exhibit showing the same thing.
Well, the relief I requested was to put a specific time, whether it be days or hours or however you want to do it. So if that's granted, I am thrilled.
Well, I'm not sure that I know at this stage, given that we have only not yet gotten through one
9
incredibly
months.
long and somewhat painful witness testimony, what that time limit might be. I don't anticipate most of the other witnesses to be as long on the stand as this particular witness has been. And maybe I can get, maybe let's just ask the state right now, like time-wise, do y'all expect any of your other witnesses to take as long
That's
as
a dumb
Mr.
question. That's a
Copeland has
stupid
thus
question.
far taken?
No, we didn't expect him to take them.
But Your Honor, this is not the only witness that is.
I cannot do anything about what happened before I was the judge.
I appreciate
I
that.
just can't.
And I'm not asking you to. All I'm saying is.
Come on.
That the state's saying that they don't expect other witnesses to take this long. There have been repeated witnesses that have taken weeks.
Okay, well.
And I mean.
Let me drill down a little bit more, okay? So are there any other witnesses that are gonna have video interviews that are anywhere as near as this witness?
No, and for any witnesses that have taken more than a few days, there have been breaks, there have been pauses that have caused us to have to take that witness over a period of time longer than we ever anticipated.
And I hope we don't continue to have sound issues, but nobody can do anything about that, although.
All right. So you can kind of see where Brian is coming from. So now listen, look what he said. She actually brought up the sound equipment. LOL. Whitaker is compromised, in my humble opinion. I'm right there with you, Brian. I'm right there with you. And it is a pattern. It is a gross pattern. This is not a one-off. This is not just a whoopsie or anything of that nature. It is a true unabridged pattern. And the idea and the notion that, because please keep in mind, the state chose Woody. Like the state chose Woody. So Woody's testimony definitely isn't a one-off. Several have taken days. Now, granted, Woody is taking much longer than that, but whose fault is that? It's the ex parte meeting that the state had with the judge. This is not the prosecution's fault. I'm sorry. I disagree with Judge Whitaker significantly about that. But I do agree with Pink right here that this is sad. This is sad to see because they're really not doing right by Fulton County, in my opinion. But not a bit. They're not doing the right thing at all. But so yeah, shout out. Thank you so much, JC. I appreciate you tagging me or commenting. I'm sorry, I'm not the best with Twitter. I'm trying my best, but I'm horrible with Twitter. But a lot of people have liked my question about starting a shot clock. That would be hilarious. To have a shot clock behind Judge Whitaker. That would be amazing. I do not know anything about Lawyer Abassi. I hope to goodness somebody don't tell me something bad about her, because I think she seems like a really nice lady. She definitely knows her stuff. Chicky Brewer, but literally I had to look her up this morning because I put her on a thumbnail and I had to find her name, had to do some scouring around and found it. So that video will be coming up. But so no, I don't know anything about her. But so far, so good. She seems like she definitely, again, as I said earlier, they seem well-spoken and well-prepared, which is something I don't think Adrian Love or even Simone Hilton, for that matter, have taken the time to put in the work to prepare to speak and even be prepared for what could happen that I didn't plan for. What unexpected thing is going to happen? And that's why I said they need to go teach elementary school for like 6 months. It'll change their lives. Throw them in the whole mix. A bad group of kids, unsupported parents, and no pencils. Like, just throw them in there. I think it'll really change them. I think it's the real Brian Steele account. Oh my goodness, I hope it is. I think Doug was replying to it, so I was thinking it was the real one. What does Darkly say? DWC, what did Georgia do before sound equipment? They chose to have a speedy trial, and the state is just dragging it out to prove guilt by taking the jury hostage. No lie was detected here. There's all truth. I agree. Yeah, I would just absolutely love for Judge Whitaker to truly stand on business, as the kids like to say, and not, and if nothing else, just call balls and strikes. Just call balls and strikes right down the middle. Y'all are out of pocket. Because Glanville, what would Glanville have done if the whole defense had not come in? Would he have made them write? Would he have admonished them? Like, they need to write. They need to write the schematics of an alarm clock and the inner workings of an alarm clock and how it works so that you can be properly, or the inner workings of a calendar invite so you can make sure you're in court on the right time. If she just came off the top rope, I think everybody would appreciate it. But they got nothing. Insert the Whitney Houston right there. Okay. Abbasi represents, I forgot his name. His name is Little Rod. I forgot his real name, though. I wrote it this morning. I forgot it. Anyways, his name's Little Rod. I'm assuming it's that young guy that really looks like he's out of place. But I thought that was Harvey Weinstein's person. Somebody's going to tell us. We watch YouTube. That's a great question, though. That was my first time seeing her. But I noticed there's also some people call her YSL grandma or whatnot. There's an older white woman that I have not seen lately. She wasn't there yesterday. She was there last week. So I don't know where she is. So I don't know if maybe Abbasi, I don't know. There's a lot of little parts in these cases, and trying to know where everybody is and where everybody's sitting and who they represent is a little bit difficult sometimes. But let me just make sure I got this ready. It is ready, but nobody's there yet. But nobody's home. Okay, so that's a great question. Hopefully we'll find out. Maybe we'll see her today. Good to see you, KSQ. Thank you so much, sir. Good to see you. Yeah, she was bringing that noise yesterday. I liked it. Look, she got her own fan club. All right, if she shows up today, y'all got to give her a nickname. She's got to get a nickname. So we know Westmoreland is Little Sis. And then everybody else has a YSL name. So, yeah, feel free. But she's got to show up. If she don't show up today, then she doesn't get a nickname. All right, what we got here? No pencils. No pencils, man. You got to get out there and hustle. I'm telling you, that will absolutely aid your love. Having to have a parent-teacher conference with the school administration and a school psychologist and try to explain why little Johnny can't read. Come on, it'll change her life. It'll change her whole way that she approaches and the way she projects herself, and definitely her preparedness. So, all right, let's see what we got. At times, a child doesn't learn without punishment. No, that is true. A parent's job is to steer a child in the way that they foresee them going. There has to be consequences. There are no consequences. I'm not saying that Judge Whitaker is these people's parents, so don't hear what I didn't say. But there are no consequences, though. Life does have consequences, and there aren't any consequences in this court. You can do whatever, say whatever, be out of range. However, it is just what it is. Court has not started yet. I'm ready. I got it ready, though. I'm sitting here ready on 10. Oh, that's Cuzzo said he forgot the young lady. That's Miss Westmoreland. I affectionately call her Little Sis. But yeah, she's fantastic. Definitely an excellent attorney. I believe she's probably a fantastic litigator. I've not interacted with her much more than a couple of times here and spoke to her in person. She seems like a great person. I'm trying to get her to talk to President Firstborn about going where she wants to go to law school. Maybe Courtney Kramer's X statement sent the state into a frenzy. It's possible. It's possible. I don't agree. I don't think Courtney Kramer's commentary on X is really that bad. That's Jason. Jason does not believe that. I'm not saying that anything about her. I'm just saying, I don't think that it has the amount of weight that we think it does. Unfortunately, Abbasi's fresh. I hope this trial and judge doesn't bring her down. Look, go back and look. I was looking at a video this morning. Yo, when they had everybody on this trial, when it was all 28, that courtroom was insane. I will make sure I have that picture for y'all since they ain't started yet. Let me do it. It was crazy. The amount of people in there, yo, it was wild. Because every nook and cranny had a lawyer or a defendant in it. It was insane. I was like, wow. So a lot has changed since they severed this case. A lot. All right, let me just real quick. All right, where is it? All right, so this is, okay, this is when they initially, okay, here it comes. Hold on. All right, real quick. Keep your eye on court, and I will make sure I get back over there as quickly as I can. I just want y'all to see this. Like, this is how wild this case was. All right, get this out of the way. Watch this.
Being introduced to our space, and as a result of that and a subsequent investigation, one of our inmates unfortunately had to go to Grady Hospital. The other thing I would just invite counsel to talk with their clients about, I know I've mentioned this 3 times now, what is considered to be acceptable behavior. This is the third time that we've had contraband introduced into this in this space. The court's concern is,
okay, wait, okay. Look at all these people back here. Look at all these people. I think this is Little Rod right here in the white shirt right here. But look at all these people. This is the entire court was full of litigants, man. Back this up. Look right
28
here.
YSL members were initially indicted, with 8 members taking plea deals and 6 members having their cases severed. Jury selection started earlier this month and was slated to last 5 to 6 weeks. But that timeline...
Look at all these people in here. That's craziness.
It might be even longer now, as the court addressed 3 contraband incidents in 3 days.
That is wild. That's how many people used to be in this trial. They've severed people, took plea deals, so on and so forth. But that is how many people were in this trial initially. That thing is wild. I'll drop the link in the chat just so y'all can finish watching it, because it's actually kind of interesting. It's about the different instances where contraband was brought into court, which is wild. All right, so I just dropped that in the chat. I do want to make sure that we're ready just in case when trial actually begins. But I just thought that y'all would find it interesting, like how many people were actually in this trial initially was, because each one, so again, it was 28. Each one had at least one counsel. So, I mean, we're looking at 30 people, 30 lawyers. That's 60 people possibly. That was craziness. That's why I said this case had no business being in Georgia's, in Fulton County. No business whatsoever. But I digress. Oh, it is a young guy? Okay, Little Rod. That's him? Man. Rondarius Ryan. There we go. So it is an L. I think I spelled it with an R. I was like Rondarius Ryan. Okay. I might have to go back in there. I think I messed it up. Yeah, there was an older white woman there last week, and then Leah Abbasi was here today. I didn't see Harvey yesterday. Whew. It's like, man, we need a scorecard, man. We need like a seating chart or something. That would be crazy. I don't think there were any more motions filed. And I also don't think that the state answered Weinstein's. So, but for all intents and purposes, Judge Whitaker got in there and said, I don't need you to argue this and I don't need a response. Like, why not? What's going on? Okay, if she comes up today, we will affectionately call Abasi YSL nice lady, nice girl. I like nice girl, nice lady. We'll figure it out. I mean, she's an adult. We'll call her nice lady. I can dig that. But she's got to come today. If she don't come today, she doesn't get an honorary YSL title. You got to show up. You got to be up in here to get the YSL title. That's so crazy. That's Steele's mom. Really? Wait, get out of here. I sat there and believed that. Okay, I got this ready. And it looks like they're firing the hole. Let's go. Some reason others not. No audio.
We're working on those.
Okay.
We won't.
Drop that one in the chat if you can hear.
We'd rather continue working on those than even attempt to start addressing that part
Okay.
today.
That's fine.
Yes, Your Honor, we're going to wait to file our motion in limine because we are working with the state and we want to make sure we're not wasting the court's time.
Okay, I appreciate that.
Who was that?
Sure.
And I meant to bring this up earlier today. I'm sorry. I have a client that's scheduled for a bond hearing at 2. I have another attorney coming in with the court's permission to sit with Mr. Stillwell briefly for about 15 minutes while I conduct a bond hearing, if that's okay with Your Honor. It's on Zoom.
Is it okay with Mr. Stillwell?
Mr. Stillwell, he usually works with me.
Did he say yes?
So it's fine with you if he takes a brief break? Okay, well, obviously hurry back because you seem to be the main person making a lot of the evidentiary arguments. So
Yes, Your
we'll
Honor.
miss you while you're gone.
All right, thank you.
All right.
Matthews in the
Anything
building.
else from anybody? I know,
Come on, house.
Mr. Matthews, you had let me know after we went off the record yesterday in the presence of the state as well that you wanted to circle back on one of the items of evidence that we had reviewed yesterday. So you can go ahead and do that.
Would you like to do that now? or-
Sure.
Okay, all right.
That's discreet. We can go ahead and get that taken care of.
Shout out to C. Matthews, Morehouse man, class of 97. Shout out.
Judge, we're before this court representing Mr. Marquavius Huey on this matter. There's an intrinsic act that was listed in the state's notice to us back in November of last year concerning item 43, which is an intrinsic act that the state is alleging should be coming into this trial. Your Honor, that particular intrinsic act stems from a November 30th, 2021 alleged incident. It's a police chase, Your Honor. In that police chase, the state are presenting to the court that this intrinsic act is somehow connected to this case and should come into evidence. That's the issue before the court. The rule that I'm asking this court to apply in this particular case obviously deals with intrinsic acts and what are the requirements for them to come in. As the court is aware, and I've cited for the court Murphy versus the state, 354 Georgia App 560. It's a 2020 case, and the case stands for the proposition that in order for intrinsic evidence to come in, evidence is admissible as intrinsic evidence when it is an uncharged offense arising from the same transaction or series of transactions as the charged offense. So the charged offense in our case, Your Honor, is stemming from an October 1, 2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. According to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car. When you look at the video, there's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not a nexus to any of the charges. And so the vehicle would not make it necessary to complete the story of the alleged crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted up. So no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. There's no indication that they were able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because of he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Dunaway on the indicted case and was taken into custody in court.
When
So,
was that?
that would have been in 2000, it was in December of 2021. Okay, so he shows up in the court and he has been in custody ever since. So as it relates to this intrinsic act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced
Well,
by this coming in.
that was an effective assistance claim. That's
Sure.
a different kind of procedural stance than what you're talking about.
Agreed, but I agree. What I'm asking the court to look at is if this court says, hey, look, I think that it is intrinsic. I do think that it somehow meets one of those thresholds.
Right.
Then the court will go to the next step of whether or not there should be a 403 analysis
Sure.
to determine whether it comes in. So with that being said, in Hines versus the State that I previously cited, there was an intrinsic act, and one of the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant, there was a word that was used that she maltreated or injured or harmed her children. And the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct. And that would prejudice Mr. Huey immensely here, because these are things that are going to go to his character. It's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I determine that this is intrinsic, that video could be played without the audio?
I imagine they could potentially play it without the audio, but there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by a preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November of 2023, they have the dates. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Good afternoon, Your Honor.
Hello.
The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle. So they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over. But
Was he driving? I mean, did they
He
see
was
him get
driving.
into the driver's seat?
He was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. And so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was.
Okay, well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. Was the reason they blue lighted him because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have, and these are text messages from November 8th of 2021. He says, just wait till after Christmas and the new year and turn yourself in, see what they talking about.
All right, okay, so, And the chase is November 30th. So this is several weeks before then.
Correct.
Okay.
And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving. And I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the New Year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes in, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from November 8th of 2021. So that's the only evidence that I would have.
All right. Well, I mean, given that he says, yeah, they might lock me up, maybe they won't. I don't think that, I mean, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just argue that he's fleeing from the armed robbery.
I know you're arguing that, but it's my ruling, so.
Thank you.
All right.
Wait, did they get chastised? What? Hold up. Yeah, I can't move the closed caption or this. They're stuck. I'm looking, there's no way to move this up to the top
with regard to
or somewhere else.
two kind of post-indictment intrinsic acts or
Wow.
arguably intrinsic acts, the stabbing in the jail and the exchange of the Percocet. I've watched the video now about the Percocet. I mean, I think that the state's rendition of what occurred is, pretty much on point. I can't hear what any deputy says, but, I don't think that there was anything particularly off about how they described what happened. I mean, I see what happens on the video. I've looked at some further case law, and I mean, how soon do y'all need to know what my ruling is on that? Because I'm kind of having the same thoughts about if we're talking about, whether these actually meet in any of the three requirements for intrinsic evidence. And then on top of that, 403, I'm just not real certain that these need to come in. I haven't made my final ruling yet, but I don't think that either of these is something that the state can't try the case without, which is not the only test, but I don't think they meet that test. So just kind of FYI on that. I'm having some.
Maybe offer some case law for the court.
Sure.
We'd offer to the court an 11th Circuit case decided June 20th, 2024, United States versus Harding, HARDING. The site being 2024 U.S. app, Lexus 14995.
Okay, and what does it say?
Your Honor.
Or if you've got a copy of it, that's fine too, or I can just plug it in here.
And Harding, we do have a copy of it.
Okay.
And it's just standing for the proposition generally that an act that occurs after the indictment
Yeah, okay. No, I've found my own cases that say that. Yeah, that's clear. It's not, post indictment does not bar it from being an intrinsic act. That law is pretty clear.
Right, Judge, and if I may, just very briefly, let me stand up.
That's all right. I mean, I
Voice is
got
just
it.
floating.
It's just,
I guess going back to the court's question in regards to how soon we need an answer from you in regards to that. I can't speak for the state. I'm not sure when they planned to try and present that evidence, but I would ask the court to continue giving it its full analysis, and especially in regards to the 403 and the overarching consideration as to whether or not they really need this particular piece of evidence to make out their case in chief. I don't believe that's the case, but I know that the court is wrestling with that. And I'll look at I don't know if I really need to look at the Harding case because we've already kind of established that that issue is not really an issue.
right.
But I'll be happy to look for some additional case law. and
Okay,
send it to
thank
the
you.
court.
Appreciate it.
Your Honor, you had
Yes.
asked the same.
Here she goes.
Your Honor, you had asked the same of me. I have been pulling some case law, trying to put it together in a coherent presentation instead of just a list for Your Honor.
Okay, sure.
I definitely do want to take a look at this Harding case where it was found that the district court abused its discretion by admitting evidence as being intrinsic. So I certainly would like to take a look at that.
Okay.
So Your Honor, in terms of other cases that talk about intrinsic evidence, we would just cite the court to Jennings versus the state, 318 Georgia, 579. And I am just giving a list right now that for the court's consideration. This is not something that we have to decide right now. This particular one is not coming up at all soon. The next case is Anderson versus the state, which is 313 Georgia, 178.
And what are these standing for?
These are all regarding the intrinsic evidence and how it is that one is, how one is to look at and determine whether evidence is intrinsic, broadly speaking.
Okay. Yeah, actually, US v. Harding, I'm pulling up what I put in my Lexis research folder this morning, and that's actually one of the cases that I was looking at this morning.
Okay. And the last one is Hughes versus the state, 312 Georgia, 149. And we too will present to the court a more coherent sort of overall arching.
All right. Appreciate it.
Argument.
Okay.
Okay, so
All right. So where do we want to turn now? What are y'all
all
ready
right,
to
let her go.
talk about?
So Judge, if the court likes, we have reviewed we haven't discussed it with Mr. Williams' counsel, but we've reviewed and looked over the Brutin motion redactions. So I'll let counsel for defendant Williams speak to them, because this is Mr. Kendrick's statement that is already in. There are portions that he is arguing are inadmissible because of Brutin. Our position overall is that Brutin specifically requires that that a defendant be directly inculpated, and at these various points, I'll let them explain why they feel like someone is directly inculpated so that I can respond, but we've reviewed them and whenever the courts.
All right. So is it the state's position then that none of the identified portions of Mr. Kendrick's statement actually qualify under Brutin?
No, there's one enumerated time area.
Which one is that?
where, and they have it enumerated as,
And has anybody sent me that statement? I think I asked, but I'm not sure that I received it.
Mr. Kendrick's statement. The
Yeah,
court didn't
that's
receive?
the one at issue right now. Yes. And maybe you did. Obviously,
make
I'm
sure.
getting lots of emails through Ms. Percifield from all of y'all, but I don't recall seeing it.
I'll make sure.
Maybe somebody could just send it now, since that's what we'll be discussing. All right, so which is the one that you don't have an issue with?
It's the point at which the detectives ask Mr. Kendrick, who do you think did it? And
Okay,
Mr.
so he's actually broken them down into little Roman numerals. So which Roman numeral are we talking about?
I wrote at the bottom my own timestamp. It's at 10004. So that would be. Here it is. It's their number 8. Well, they're number 9 really, but they're number 8 specifically.
Detective Gaither mentions Mr. Stillwell, the one that is labeled that.
Right.
Okay.
Well, it's labeled, I'm sorry, Mr. Kendrick mentions Mr.
Okay.
Stillwell telling detectives who they say
All right,
killed.
that's 8. But, okay, and you agree that that should be excised?
Partially, because what happens is that, this is the part that we would ask, that we specifically would argue, is not inculpating anyone.
Okay.
What Mr. Kendrick says is, they say our crew. And he's, in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And then they specifically say, who within your crew? And at some point, Mr. Kendrick says, they say Shannon. That part we would agree comes out, but they didn't enumerate it exactly that way on this sheet of paper. So they say Shannon, we would agree comes out. He then says, they also say Woody, and then they say Shannon and Woody. So the part where he's naming people that they say did it beyond our crew, or people that Mr. Kendrick identifies as his crew, or, in acknowledging that there's a crew, we would argue that part, we would agree, concede that part definitely comes out.
Okay, so you're saying that they say our crew isn't Brutin, but when it goes further to say, they say, whoever the they is, but they say Shannon, they say Woody, that part you agree?
Yes,
can be
I would say
redacted.
that specifically Shannon comes
Shannon,
out.
they
Yes.
Okay. All right, and every other one we're gonna need to look at.
And yes, I believe we should look
Okay.
at the rest of them.
And has anybody come up with any case law about kind of the interplay between Brutin and a RICO or gang kind of charge? Okay. Okay, that's fine, as long as you're getting me something. They're two separate, well, not entirely separate, but I think we can do this without knowing the answer to that.
Can I ask a question? If the state, if I heard correctly, if the state is not, over objection, by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you're going to mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not ask the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear Mr. Kendrick say. So we don't intend to play the video
In
by
toto.
video, right?
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And
Okay.
generally speaking, the overall method of introducing the majority of his statements would be through questions to avoid any implication of
Okay.
Brutin.
All right, well, if there are particular portions that you know you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that'll probably be helpful.
Okay.
That's easier, because if it's question and answer, it's easy to deal with.
Yeah, sure. So just let them know which of the portions, but okay, let's go through all of these if we need to, which it sounds like we need to.
Did you send it to me?
So do you want me to be, is there a transcript for this statement or do I need to be
No,
listening to the
There's not a
audio?
transcript.
We don't have a transcript of this statement.
Okay.
But
Sorry
we
about that.
can. I don't know how they want to do this. Since the defense has timestamps on it that
Okay.
are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format because I have a specific time and
Okay,
they.
sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says? Okay, that'd be great. Okay,
Yeah.
sure.
Can I just bring up another concern on this
Uh-huh.
subject? The concerns aren't limited to Brutin. I still like, we're talking about playing a tape where Mr. Kendrick says that other people are saying, he's not saying anything that he knows, he's not telling on anyone, but he's saying other people are saying
Yeah,
that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
yeah, no, I agree.
I-
That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So.
But that's
I-
most of this.
Well, I was going to say, we're not intending to elicit that.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Brutin is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talk to Mr. Kendrick about the Donovan Thomas murder?
Okay, that answer would be yes.
Yes. Did generally speaking, what?
Let me ask you this. Do you think that it's relevant for the jury to hear that?
Look at Doug.
Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, the people on the street think X, Y, Z is relevant. The relevant part is his acknowledgement that
Our crew.
was beefing with them. There
Okay.
was a us and a them that was in conflict.
Okay, so then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay.
Thank you for actually.
All right, so when we're going through any of these other ones, if there's something similar, just kind of let us know that, okay?
Was not having that. He was not having that at all.
And Judge, we've just now sent to the court, we're sending to the court the October 6, 2015 interview. Does the court need the evidence reviewer player sent to it again?
So No, I don't think so. But if we're going to go by Mr. Steele's playing of it that has his timestamps, I guess I'll just watch that on Zoom. Are we close, Mr. Steele? Okay. Okay.
And I don't want to belabor unnecessary points.
Mhm.
We are looking at it, and I was looking at this for the purpose of Brutin.
Right. Sure.
Yeah, see, this is the part where I'm talking about. It feels like they're not prepared to do certain things. They only had like 5 or 6 tricks that they're ready to work on. And when they're given homework, given class time, a study hall, they have a study period, they don't really know what to do. And they should be working. They should have already had this stuff parsed through. I'm sorry, this is it's such a waste.
Any other little discrete items we can deal with while we're waiting?
Yeah, like the motion that you ignored yesterday. How about that? How about that motion? Amazing. Amazing. Yo, thank you so much, man. There's 874 people watching this stream with us. Thank you very much. I really appreciate it. They might be like, they don't know who I am because I don't have my hat on my head. They might be like, who's that guy? Anyway, I appreciate you stopping through, man. Make sure you hit the like button. Chat, the best live chat on the whole planet is right there. It's at your fingertips. Yeah, I'm totally lost on why they don't have this stuff done. Because remember, this is an old case. It's not new. I think they might be. She the one. They might be waiting for the judge to do it. Say that louder, please.
I mean, we're certainly going to have to do that. I guess we can get started on that.
Wow.
Unless we're really close. 1 minute away. All right, we'll just hold for a minute. Or so. Come on, Mr. Kokobo. No pressure. Mr. Steele, how'd your oral argument go this morning?
The argument was good, but no one remembers the argument, so we'll see what the opinion is.
Okay.
I agree, Judah. Always saving, always rescuing.
Yeah, sure. I mean, we might as well fill our time some way.
So it's in this courthouse. It says indictment on the cover. Second page has, typical indictment things, waive formal reading, etc. Third page has the grand jurors in Fulton County names. Then count 1 through count 6. Former district attorney Paul Howard does hereby charge the appellee with murder. Goes like that. So I didn't try the case. I did the appeal. The Honorable Judge Newkirk granted the motion for new trial, finding no jurisdiction because it was an accusation. So the Supreme Court was very lively.
Interesting.
It was an interesting case, and then it got so narrow. I was being asked, well, this is a novel issue. How would a lawyer know? You're saying it's deficient performance. How would a lawyer know? Yeah, I'm like, well, if I know, then anybody could know because I'm not that deep. So that's what I said. But it was fascinating. It was intellectually stimulating.
Interesting.
And thank you for letting me attend.
Absolutely. Okay.
Brian Steele. Brian Steele.
We spent all that time on the wrong interview.
All right.
All right. Well, maybe we can turn to the PowerPoint issue and at least start making our way through that. Unless, are we ready now on the right one? Okay. So we want October 6th. Is that right? Okay. Lawyers and tech, they just don't mix.
I hate to defend Mr. Kokomo here, but this is a lawyer issue, not a AV issue at this point.
Okay.
That is purely comedy right there. We're back to the judge and prosecution v. defense. And Doug had to go take a walk. He's like, look, this is what I'm talking about. This is what I'm talking about. He's like, look, I wouldn't have said it like that, Gainesville, but I agree with you. So nonetheless, he said, man, this is crazy.
So, Ms. Love, I know you said the state's timestamps were somewhat off, but can you get close? Maybe that's...
This is embarrassing.
Maybe we just go that way, since this seems to be taking longer than we had anticipated.
Doug should just have a copy of his motion, like blow it up into like a poster. At this point, Doug should just be walking, make it a suit coat jacket. I mean, maybe that would work. And it's usually the state. I agree. It's the state. It's not the it's not the defense. It's the state. They're always off. You caught that too? They're never right. They're always off because they don't have editors in Fulton County. That's the thing. So they're editing using Premiere, but I'm editing over here using Adobe, another platform. So that's probably the reason why. That's something to think about, Jody. Something to think about. If only y'all were prepared. How crazy an idea is that? She's been doing this a lot. Blurry Line says, is the judge really getting testy over a couple of minutes where the defense is doing the state's job?
The defense thinks they've got it and the state thinks they've got it. So the defense has got it. All right, let's do it.
All right, let's see it.
Yes.
Just to avoid the inevitable confusion, the numbers, the times that we are giving is based on the MP4 that was made from the evidence reviewer. So, and we can figure out how to convert that. But the 50 minutes, for instance, is not going to be 50 minutes on evidence reviewer.
Okay.
Correct?
All right. Well, thankfully, we've got the kind of general subject matter listed as well, so that'll help us.
Do you want this marked? I assume we have to have this marked somehow. We can put on thumb drive.
What we're playing now?
Yeah, but in case God forbid there's an
Good to see you forging anvil. Man, I'm sorry about that, brother.
we were looking at since we were saying 50, and we could do that.
Sure. Yeah, that's probably the easiest way to do it. So I guess this is the hearing on Mr. Williams' Brutin motion.
Can we call the exhibit that?
Yeah.
We'll give it to Ms. Winfrey if the state wants to see it, that exhibit in the legal file.
Yes. So this will just be Defense Exhibit 1 to the Williams Brutin motion concerning Mr. Kendrick's statements.
And we'll have that thumb drive today.
Thank you.
No, thank you.
No, thank you. Thank you. But they're not, because they're not using, apparently they don't have the same editor software. Who is that?
Anybody but anybody can pick up? Oh, of course, that ain't no question, but that ain't like, that's on some whole load of shit. Like, that's like my rep pump. Like, we do shows, he help me out. He said, like, he bring me on to his show, just help me, just sell both of them.
They need it. They need to have a nap. This is crazy.
Your Honor, we're going to start at 49 minutes.
Okay.
And it should be Detective Gaither saying, third, is that the possible reason that people went after that meeting in retaliation? That's what it should be. So it's the detective asking the question. That's why I don't know if it's going to be needed because of the question, but that's the first.
All right, and give me just a little bit more general idea of what they're talking about at this point in time.
Okay.
Yes.
Detective Dennis is in here, Detective Gaither's in here. co-indictee pled guilty. He also goes by Duke, he is the word Duke. Regarding the issue where Mr. Kendrick was tased, he was actually chased by police and tased.
Okay.
And Mr. Kendrick then mentions Duke or Mr. Arnold about the involvement in that. I didn't challenge that, because I didn't think that's a Brutin issue. And then Detective Gaither talking about Duke, and then going right into whether THUG is a reason that people went after them, meaning that there was this.
Why, whatever that incident was,
Yes.
occurred, okay.
So, to me, I'm doing, I think, what the court wants, but this will never come up on a question answer, because no one's going to say to Detective Gaither, I would hope, did you ask about Jeffery Williams to Mr. Kendrick? It wouldn't happen like that, but that's the first one.
Okay, well then, maybe we can nip that one in the bud.
So there's, if Mr. Steele would not mind just letting that part play from 49,
Okay.
so that we could.
Don't bust me, but them is 40 on here. When I got tased on Bankhead, it was here. When I got on Collins Boulevard, that was man. I was leaving my little boy from born, so I had to help him. He was in the car. It's like, man, y'all see all this shit going on. You got it to me. I try to keep one deal with that one, cause it's like it should go down anytime. Like, man, he been on some hang, jealousy. So why they coming at? I ain't talking about Duke. I ain't talking about what folks you roll. Why they coming at you? So they thinking like I'm bad at it. They think I think I'm bad. Because I used to carry myself. Like I see of other people you associate with. Probably. Anybody you can think of? Oh, man, of course, that ain't no question, but that ain't like that's on some whole other like that's like my rep pump. Like we do shows, he help me out. You feel like he bring me on to his shows, just help me just sell ball. So I don't know why would you feel like I took your part, your spot? A lot of people feel like Bloody J. A lot of people feel like I took their spot. You know what I'm saying? But it's not. I don't get around on any.
Welcome, DC.
I'm grown man. I got whatever I got going on. It was just spot. Yeah, ain't nobody. Yeah, he was grown, bro. Got spot. Right. Grown ass man. Who the hell is he? But then when somebody had to tell me like, bro, you know these folks probably feel like you take their spot. Right. So I had to think about it, look at it from other people's perspective. Okay, that may be what it is. Yeah, but everybody.
Okay, so Your Honor, there's no part that I hear Mr. Williams' name mentioned in there. I didn't hear Thug or Mr. Williams' name.
I heard my
mentioned, so
own
wasn't-
name in there.
I don't.
They accused me.
Okay, well, let's
What is
just
that?
ask it this way. Do you have any intention of who's this coming in through?
There would be either Detective Thorpe, probably Detective Thorpe later on.
Is he even in this interview?
He's right there in front of you. To the left.
Oh, okay. I thought you had said Dennis and Gaither. but-
Dennis and Gaither are sitting in front of Mr. Kendrick. And Detective Thorpe is to
Is
his
also
right.
in there.
He
Okay,
is.
all right.
There are three.
So, I mean, you're not going to ask Detective Thorpe if Gaither asked if Williams was a reason why.
No.
Okay, so
absolutely
that
not.
would be one then. This example would be one where you could say, we don't intend to ask that anyway.
Okay, so we do not intend to elicit or ask whether Defendant Williams was
All right, well, let's
whatever.
circumvent spending the 5 minutes listening to it if you know you're not going to use it anyway, okay?
I agree.
That would be super helpful. Okay, next.
But so when, again, this is one of those them, us, we, them situations. It is simply not one of those situations where we would be saying, you know, are they coming after y'all because of Thug? Are they coming after you because of we wouldn't be eliciting anything about another defendant. But if Mr. Kendrick is talking about a us and a them, like he is in this circumstance, they want to take my spot, things like that, then we would be putting that in. The reason I was saying we're looking at it in terms of Brutin is because if he's not talking about a defendant and he's not saying that person's name and inculpating him, then it's something that we will likely use. If there's a point at which I know that I'm just not going to even touch it, I'll do as the court has instructed, though. If, and say, no, I wasn't even going to ask that anyway. It doesn't do us any good.
Okay, so then what I hear you saying is that while you're not going to elicit that somebody asked if Mr. Williams or Thug might be a reason people are after them, you would maybe ask about some part of Mr. Kendrick's answer there, which said something about whoever they is, wanting to take my spot.
Yes.
Okay.
And that we contend is not Brutin.
That would not be Brutin. Okay. Next.
Hey, they is the best live chat on the
39,
planet.
And it should be Detective Dennis speaking. And he talks about Mr. Shannon Stillwell. He calls him Shannon.
Okay. And then you wouldn't be able to mention Mr. Stillwell. Is there some part of this little bit? Go ahead.
I'm sorry.
Go ahead.
So he does not say that Mr. Stillwell bought the gun. He does not say anything that directly inculpates Mr. Stillwell. And my understanding is that Brutin does not prohibit the mentioning of.
All right, let me just hear it. I see this is the way it's going to go.
Playing from 52-14.
And this is before buying the gun for what? What are we talking about here?
We don't know either. Don't worry, Judge. We don't know either.
Anybody?
So one of he was stopped with a gun in October and one on January 28th. And they're talking about the guns that he had in those situations. January 28th and October 1st of 2015.
All right, and these are overt acts, or are they?
Yes. One is in intrinsic, January 28th.
Okay. All right, go ahead.
Why don't you bring it? True. But I mean, like, my first man, like, fuck these big ass guns. But the second man, like, I got to ride with something that's gonna protect myself. You feel like, right? How long have you had it? Like, a couple days.
Did you buy that one after you spoke with Shannon?
I bought like before all this stuff.
I don't think you can stop it. That seems pretty inculpatory of another defendant. Did you buy it after you talked to this person? As if, no. Don't
leave that part out.
That one's out. Okay. Next.
It's right after that, but it's the same thing, Your Honor. Okay. Now it's Mr. Kendrick speaking about Mr. Stillwell. He includes Mr. Arnold as well to clarify what Detective Dennis just said about the gun. And that's at 52-51.
Just to go back just a bit, he wasn't saying that Shannon told him to buy the gun. He was orienting Mr. Kendrick as to a conversation with Shannon. It wasn't saying that Shannon tell you to buy the gun. So it wasn't inculpating Shannon. I think that it may be helpful to hear before the part that they started on. It's like Did you talk to Ms. Hilton? Yes. Did you buy the gun after you talked to Ms. Hilton? Yes. But it has nothing to do with Ms. Hilton told me to buy the gun.
Well, I mean, unless you can make it really clear that all that's doing is orienting him in time to something, but to have the question be in front of the jury that is, okay, you had this gun that you got in trouble for. Did you buy it after you talked to one of your co-defendants? Okay. Just seems too Brutin-ish to me to permit this. And the state ought to want to try a clean case.
We do.
So
That's fine. We don't
that
have to
would not
keep
be
that
clean.
in. Okay.
Go ahead. Next one.
This is 5250. You should back it up. This should be Mr. Kendrick. Mr. Kendrick bringing up Mr. Stillwell and Mr. Arnold about clarifying the answer that you were just discussing, although I think that's out, actually. So it's really 54 minutes we can go to, and that should be Mr. Kendrick. And he mentions Mr. Copeland, Duke, or Mr. Arnold, and Rich Homie-Kwan, Mr. Lamar, and Mr. Stillwell. And he doesn't want to be associated with them. So we ask that Mr. Stillwell's name be redacted.
Put MM79 in the chat. Man, I didn't know you could change that. Dude, come on. Dude, change the whole game. Put MM79 in the chat.
See, that's why I be a man today. That's why I fucked up it. I be on more of a defense. It's like, if I wouldn't got that call, I would stay asleep. Right. It show you that though, like I'm so much of a good partner and friend, that way it hurt me. You know what I'm saying? Yeah. Well, I mean shit, this like it. And he get to go with it, like he get out there before me and all that and this shit. Yeah. So it's like, God damn, bro. Like it made me look at my loyalty and my friendship like, you can't be bending your backward for a lot of these niggas. And that's why I feel back from the people we all just saying. Right. Which was my original crew member, like the people I was rocking with. That's why I feel back. So it's like, I ain't get 100% from none of them. So it's like, y'all ain't gonna be getting my 100%.
Who are you speaking of when you said that?
From Shannon Wood, whoever. Dude, it's just everybody period. Going, like everybody, cause all of them have been together at once. Like all of them rock, joke on all of them. So it's like, once I figured out, and it's like, I don't want no part of it. You feel like? So it's like, what are you gonna?
All right. I mean, he says something about being regular crew members and not getting 100% from them and then saying them by name. I think that's a Brutin.
This looks terrible.
So,
it looks crazy, man.
If you do intend to ask about this.
Not having to mention Shannon's name.
Correct.
Everybody sounds like Woody.
Your Honors, should be around 58:10, and of course, they'll announce the time to orient. But this, Mr. Stillwell swung first outside of Club Crucial. That's the fight that you've been hearing about on the 6th day of January, 2015.
Well, I might not even need to hear that one.
Your Honor, just before we go to that one, I just want to make clear, Mr. Stillwell's name is the only one that is on trial that Mr. Kendrick mentions at the last little clip. Mr. Copeland, Mr. Arnold, Mr. Lamar, they have those names listed in their motion. I'm sure they don't intend that. That is a Brutin violation. They're not on trial. So we would believe that it's okay to mention those names. But
Does the defense want to be heard at all on that, or what your position is on that?
I'm still researching, Your Honor,
How did y'all redact this indictment? In
we've
what
been
way?
asking for that to be redacted. It's been denied.
Well, what got read to the jury at the beginning?
Everything except, I think, overt act 26 maybe was redacted, maybe 2 overt acts, but I have to check my notes on which ones. Otherwise, the entirety of the indictment was read to the jury.
Including the names of all of the co-defendants that are not on trial?
Yes. Every one of them.
Your Honor, at the time, they were on trial. So severance happened during the course. So when we first had the indictment read, it was more than just the 6 that are
Was it
present in the
all,
court.
whatever, 19 of them?
With the exception of maybe,
Yeah.
the ones that hadn't yet been apprehended.
Yeah, so everyone was here except for,
And everybody at that point in time was on trial together?
yeah,
Okay. I mean, it's been a long time.
except for the ones that pled and a few that were not apprehended, yes.
The ones that had not had attorney.
Huh.
And some that had not been apprehended. So there were, I think, 6 that weren't.
So Mr. Kitchens is indicted. He pled guilty around Thanksgiving of 2023. The jury first came upon us January 4th, 2023. So I made a mistake. Mr. Kitchens pled guilty under
Thank you,
Alford
Owen.
in November of 2022. Mr. Arnold did the same. Mr. Sumlin did the same. Mr. Stevens did the same. Mr. Murphy did the same. Mr. Sledge did the same. Thank you. And I should look at the indictment for more. Mr. Garlington never had a lawyer, so he was already removed. Mr. Wani Lee pled guilty around the same
Who
time.
was that last one?
Mr. Wani Lee, L-E-E,
Oh, okay.
and Wani is W-U-N-N-I-E.
Yeah.
So, the state, I'm sure it was a miscalculation, but these people were all included in everything in the indictment, but were not on trial before the veneer panel was first put upon us. And if I left somebody out, Mr. Eppinger was with us for jury selection. Then he got, something happened and he got removed after that. So he was in a different category. Mr. Blaylock pled guilty after the veneer panel.
Mr. Blaylock has not pled guilty. Mr. Blaylock was severed as well. So I believe I said everyone who had not pled and not been arrested was present. So there were individuals who were severed subsequently. So Mr. Blaylock was severed after the jury was impaneled.
That's true.
Mr. Dorsey was severed. Ms. Eppinger was severed. Mr. Mender was severed after the jury was impaneled.
Right. So the people I mentioned pled before the veneer panel was read the indictment. And I'll look at the indictment. There may be a couple more, but that's my memory.
Right. So I have no idea why.
Winfrey was severed before we did. He was apprehended, I think, afterwards. So name was read to the jury, but he was never with us.
So
He said they're not like us.
if they had not pled and they had been arrested, they were all on trial. And so obviously those names were read. Were the names of the people who hadn't been arrested and hadn't pled been read? Were they read?
The names must be
So
read.
everybody's name was read. Okay.
Read them names. Them names must be named.
And I don't know if there were any counts of the was every count of the indictment read? Even if it was only against somebody who had already pled?
Yes, Your Honor, because I think it was pre-recorded, and so
Help a brother
everything
out.
was read. I think it's your question. Yes.
Okay. Was there any objection to that? Okay.
When the court says objection to that, and there's a yes, to get clarity, because On the yes?
I mean, honestly, at this point, that'll be a motion for new trial issue if it gets to that stage. I'm just trying to figure out what this jury has heard. Y'all would not intend to send out an unredacted indictment if we get to deliberation, right?
We had actually talked about redacting the indictment. I think we were
Okay,
actually,
all right, well, good, because I don't think an unredacted one should go out. All right, anyway, back to what we were doing, so I mean, the question was with regard to people who are not on trial here now with these 6, is there any kind of objection to those people being mentioned?
Yes, so I'm finding Brutin under conspiracy
Yeah,
and directly impact, and that's what I have to get to the court.
okay, all right, well, why don't we circle back on this one then? Because that, obviously what the law is will determine what the answer is. So it's definitely out with regard to naming anybody on trial here other than Mr. Kendrick, but with regard to anybody else, TBD, depending upon what the law says about that.
yes, Your Honor.
Okay. So y'all get the next one lined up and let me jot myself a note on that.
It definitely does. Thank you. It does help. Thank you so much. They're ultimately arguing about names in the indictment. Is really what they were arguing about initially. Oh my gosh. Because in the interrogations, some names were mentioned that are not actually in the indictment, basically is what they're talking about. On the Kokomo.
Detective Gaither is asking, this is at 10055. So then after Woody got jumped, you know who Woody is? Who shot up the studio TIG? Mr. Kendrick states, I don't know. Mr. Gaither said, I heard your crew shot up TIG after Woody got jumped on. There's a discussion of where is TIG. Then Detective Gaither says Metropolitan, like over there by Thug Studio. Mr. Kendrick asks, where's Thug Studio at? And then they talk about that location. They talk about YF and Lucy. And then at 103, Detective Dennis say, you still on Bloody J when he got locked up. And it goes on to that event. And
So is this just because Mr. Williams' studio is mentioned
Well,
to orient people to where things are?
well, at 102, it's just about the studio, but I was targeting the RICO conspiracy. So I was targeting the, this is where, actually, I'll withdraw that because
Okay.
it does not mention, I apologize.
All right, no problem.
All right, number 105:19, 1:05:19, Detective Dennis mentions Mr. Williams' quote unquote girl regarding a shooting, supposed shooting of that event. And that is, it's 104:32. Detective Dennis states, didn't you catch them down bad? That's a reference to Mr. Kendrick's music. They laugh. It's a verse in a song. And then Detective Dennis says, so who shot up Thug's girls event? Or did you hear about that? And Mr. Kendrick says, I don't know. That's my first time hearing about it, so I wanted that excluded.
What's the response?
Doesn't, number one, evidence of that has already come in through Dennis, but number two, that in no way inculpates Mr. Williams in anything because it references
His
him as,
girl being a victim.
right.
Okay, yeah, I mean, I don't think that's a Brutin issue.
So my issue with that then would fall back on a different issue then. What's the point? The answer is, I don't know anything about it, so we're now just using
So
the
now we
question.
have a relevance objection. No, we'll do them all at the same time, so
So,
we don't.
I don't have a problem not having him since he doesn't know anything about it, keeping that part out. He said, I don't know
Okay.
about that. I don't have any problem keeping
All
that
right,
part out.
thank you.
Next is 108,
Okay.
1:08:40. And this is the part you heard earlier that may be stipulated to. Mr. Kendrick mentions Mr. Stillwell telling detectives who, quote unquote, they.
Right, and on that one, what would be permissible to ask
They
about
is his live
that,
chat.
At around this time,
They were beefing. with
our crew were beefing with
them.
the other group. But not anything about the rumors or anything like that. So that one I think is clear. Okay. Next one.
The next, Your Honor, will be it's really the same flow, but it's 1:08:51, so it's only 11 seconds later. And Mr. Kendrick, mentions Mr. Copeland sharing that he was tied up with Mr. Stillwell and specifically, and then Mr. Kendrick identifies a photograph 8 seconds later of Mr. Stillwell. Then Detective Thorpe mentions Mr. Stillwell and clarifies that the word is that Mr. Stillwell and Mr. Copeland killed Mr. Thomas. And Mr. Kendrick speaks to that.
We
So
don't have any intent to bring that out.
Any of that?
Right.
Okay.
Okay, the next is 1:11:30. And it's Detective Gaither mentioning that Mr. Stillwell is the person that whoever everyone is, brings up related to the murder of Mr. Thomas.
And this falls in with what we initially said, that when they were talking about who they said killed Donovan and bringing up Mr. Stillwell's name, we have no intention of doing any of that.
Okay.
Okay. The next one is 1:13:44. And it's Detective Thorpe, I believe.
All right.
And he says, people talk to you in the city, all put you involved in the murder of some kind. Mr. Kendrick denies it, says they are lying. Detective Gaither says, you think anybody going to tell the same story? Mr. Kendrick asked, what did they tell? Detective Gaither said, I heard you was in the car. Mr. Kendrick said, what car? Detective Gaither said, the Infinity rental from THUG. And then Mr. Kendrick said, no, I wasn't. Check whatever, my phone, whatever you want to check. And then Detective Gaither says, we did. It was said a whole lot. And then they go off on that. So I was objecting to Mr. Williams or THUG being mentioned.
Your Honor, that whole, all of that colloquy is part and parcel of them talking about who people said killed Donovan Thomas. Anytime we're talking about any of these defendants being rumored to have killed Donovan Thomas, the state has no plans to get near that part. Now, Mr. Kendrick denying that he was in a rental by Mr. Williams, we would proffer that type of information because it would not inculpate Mr. Williams.
Yeah, I agree with that. I mean, I think it's already in evidence that Mr. Williams rented an Infinity, right?
Yes.
And up for dispute whether that was involved or not.
Right.
But saying, the Infinity that he rented doesn't inculpate him directly. So that I would be okay with. I mean, I don't think there's a Brutin violation if you ask or get an answer that talks about the infinity that Mr. Williams rented or that Thug rented. Okay.
The next, and I'm skipping based upon what the state just said about that whole colloquy.
Okay.
So it would go to 1:18:31. And that's after 1:17:35. Mr. Kendrick reaffirms he has nothing to do with the murder of Mr. Thomas. And then at 1:18:25, Detective Gaither asks about NARD, N-A-R-D, and DUWOP, D-U-W-O-P, where they are now. And Mr. Kendrick explains he's almost questionably locked up. And then the target event, Your Honor, is Detective Gaither asked from January 10th until today, how many times do you think Shannon been locked up? We'd like that redacted.
My apologies for leaving that out. I would not put that in.
Okay.
Okay. The next one.
The part about Mr. Stillwell being locked up, the other part, yeah.
Yeah.
The next one is 1:21:25, Your Honor. And at that point, Mr. Kendrick had shared with the detectives that he went to Miami after January 10th. Detective Dennis asked who all went. The answer by Mr. Kendrick is everybody. Detective Gaither said, who is everybody? And then Mr. Kendrick starts naming little d, everybody, and then Detective Dennis points to the photograph of Shannon Stillwell. Mr. Kendrick says yes. He says yeah, actually, Y-E-A-H.
Okay.
So that's the part that we were taking out, the picture and the pointing.
Well,
this is just him saying, here's who all went to Miami.
Yes, immediately after
Doesn't
the killing.
inculpate anybody directly in anything. It might be argued to be a part of the evidence, but that wouldn't be a Brutin violation.
Okay, we're just raising objections then, if that's okay. And when I say okay, I'm not waiving anything.
I understand.
Okay, I said okay, but thank you.
Yeah.
All right, the next one is going to be included. Did Thug went? Was a question by Detective Gaither. The answer is yes or yeah, so I assume it's the same ruling.
Yeah.
The next one, Your Honor, would be and I assume it's covered by your ruling. Detective Gaither asked Mr. Kendrick, how long did Mr. Williams stay in Miami? So I'm assuming it's the same ruling. So I'm moving on from that one.
Okay. So the one about before that 1.23.06 about Mr. Stillwell getting calls.
Yes, I should have included. I skipped that one accidentally.
And what'd you say, Ms. Love?
I'll let the court decide on that. I'll let the court hear that because I didn't count that as inculpating because everybody was, what he's contending is that people were calling, but I'll have to hear that part again.
Okay, let's just hear that part because I'm not sure what it says. And
Start at about 1:22:40 if you can, Mr. Kokomo. And what it should say is, it should be Detective Dennis asking about what conversation was like on the way down to Miami. Detective Dennis specifically, I believe, said, Your Honor, the ride down had to be some type of, just like you just said, like when Duke got jumped on, people started hitting your line. So y'all started to get worried, and Mr. Kendrick said, it wasn't on my conscience. And then in there, they talk about Mr. Stillwell was probably getting calls.
all right, let's just hear.
One of the conversation.
Everybody just sitting there like,
Yeah, I was just stoned with it. Like I get my own sprint. I'm arguing.
right, what I'm saying is, the ride down had to be some type of,
I don't know. I didn't
because
know
it's
anything.
just like you just said, when Duke got jumped on, people start hitting your line.
Yeah.
What's going down? So y'all had to start getting word that these names are out there as nut just got killed.
Yeah, but it's like, they probably got getting like calls and saying shit like they think it was them, but it wasn't on my country or folk might call me. Yeah, you know what I'm saying? They want.
But if they your people, it's almost like you guilty by association to an extent where if this happens.
We wouldn't have any problem taking that whole last 2 or 3 sentences out. Like, they were probably getting calls thinking it was them, and then Dennis saying it was your people, you guilty by association. Like that, those 3 or 4 lines, we don't have any problem coming out.
All right, does that cover it?
Yeah, Mr. Kendrick, I'm sure it covers it. Specifically said Shannon, so I'm assuming that's it covered it too.
Let's make sure.
Yes,
Okay.
yes.
Okay,
Excuse me, Your Honor, can we take 5 minutes before we continue down the list?
sure. Yeah, that's fine. Let's take a quick break.
Thank you.
Sure.
All right. So, yes, they're parsing through things and they're moving things along. But a lot of this could have been done and should have been done, I really believe, well before this trial got started. Whether or not, I'm trying to be gracious because there was like 25 people at the beginning. It was a lot of folk. It was a gang for real of people. So I understand that in the beginning, they probably weren't able to get through all of this. And I understand that. I want to be understanding, not act like I totally don't get it. However, what we're seeing right here is just such ridiculousness. And Judge Whitaker is responsible for this. I think it's cool that Doug is just sitting there being quiet, looking at her, because he said yesterday, and she shot him down on, he shot her down. She shot him down on reviewing how to speed this trial up. And she still let them just horse trade. I mean, they're just lollygagging, taking their own sweet Tuesday. And every time Judge Whitaker gets upset, she got to look over there at Doug Weinstein, looking at her saying, as if he's saying, see, I told you, this is what's going on. So shout out to Doug, man. Again, that was a great article. If you didn't see it yesterday, Doug wrote a very scathing motion over the weekend about why this trial is going so slow, and that he's asking that it be sped up, and that the judge actually requires that the state does their homework. And it doesn't look like they've done it still. What does Retire say? If you have an idea, a concern, would like to share, hey, email management, of course, dwc@gmail.com. Yeah, YSL Doug is crushing it. I mean, at this point, she's allowing Love to redefine words and give words meanings that maybe they don't have, or maybe somebody's not using it like that. A crew, a posse, sure, all those could very well be gangs. They could, but they also could not, just the same. And more than likely, again, I'm not saying that these guys are, choir boys or anything of that nature. All I'm saying is that the evidence just doesn't seem to be there. The jail interrogation looks like it's going through the matrix. It sounds like cats being chased by tin cans. It sounds horrible. So to me, it's just a waste. It's such a waste. And this is their evidence. This is what they are banking on. This is what they're rooting on. And as Matthews just showed right there, there's a lot of stuff that they're rooting on that has no basis at all. Like, that was crazy. But shout out to YSL Matthews for straightening that out. White beard, setting them straight. And we're not even going to talk about this one, Dixie Doodles. She is literally helping. And she's been doing this, though. This is not new. She's been helping her a lot. As I said in my opening monologue, I don't think, as I said in my opening monologue, I don't think they ever spend time practicing what they're actually going to talk about. Whether it be in the mirror, talking back and forth in the office, anything like that. They've never ironed out some of the very necessary things that they need in their to be successful. I don't believe that they've done that at all. And if they did say they would, if they say, yeah, we did, we do it all the time, I need to see some video evidence, because Love is like she's searching for words. Like, you could not have said these words before you got up here to say these words. And again, I'm not saying you got to have them memorized, but my goodness, in the morning, memorization might not be bad. It might not be bad for you, or at least a deep understanding of what you said, what you're saying. What else do we got right here? A mistrial isn't out the window, but I don't think it's going to happen. Note how often the judge pins when the prosecutor's errors or borders due to process violations. I'm going to tell you right now, debut 904, I will be thoroughly surprised if Judge Whitaker pops up and says and declares this a mistrial. I will. Now, again, 2 weeks ago, 2.5 weeks ago, I was right there with you. I no longer believe that she wants to bring this thing. She wants to bring this into port. And I think it was Monday or maybe last week, I kind of explained, maybe over the weekend, I explained my rationale for why I believe Judge Whitaker is doing this and why she is allowing it. Here, I'll just explain real quick. Judge, 2 fighters. Referee, two boxers. One boxer is getting pummeled by the other boxer, but they don't fall down. They're still answering the count. Every time the referee talks to them, their gloves are up. They're awake. They're on their feet. The referee cannot, you would not want the referee to stop the fight. You want to knock your opponent out. So therefore, you're just like, okay, the referee could knock him out. But the referee could call the fight. Their side could throw in the towel, or I could just knock him out. At this current moment, where I believe is happening at this moment, is Judge Whitaker realizes that the defense is winning. They're winning, hands down. Therefore, if she declares a mistrial, it's going to go back to, and she can't, if she doesn't do it with prejudice, it's going to go back to 0 and they're going to have to do it all over again. Or she could just let Brian Steele and the defense finish this out. On the score, on the judges' scorecards, they're winning. 10-7 rounds, easily, 10-7 rounds all around. They're winning, and the judges are the jury. The jury is not feeling what the state is saying. I don't care what anybody's telling you. So, now this is a political answer. In order for Judge Whitaker to be seen positively in her next assignment that she wants to get, which is the Georgia Supreme Court, it would not look good for her to declare a mistrial on this trial and cause all the brouhaha that's going to happen. But if she lets it get to the jury and the jury acquits them, it's over. There's no more need for appeal. There's no more need for horse wrangling. And Judge Whitaker's hands are clean. She didn't have to declare a mistrial. So she, in my mind, this is just what I'm thinking is happening. She's allowing this to go all the way to the distance, even though I literally want her to stop it. It's going the distance because she realizes the jury is they're going to absolutely acquit these guys. And she won't have to do it. She won't have to be the one that has, oh, you threw out the Young Thug case and now this, that. No, her hands are clean. She's fighting to get now, granted, it looks bad because the prosecution is horrible. They're not good fighters, okay? We are not looking at 2 equals, okay? We are looking at a giant and a pipsqueak. We are not looking at a team that is ready to really take this the full distance. There's no way in the world you're going to convince me that the state is ready to compete against Doug Weinstein, Shard, and Steele. As a matter of fact, you could pick anybody over there. I'm comfortable that if they were the only ones, the only 3, they would still shellac the state because the state is not prepared. Judge Whitaker, rather than throw it out and run the risk of it not being, getting an appeal, going through all that brouhaha, you know what? If we get this through to the jury's going to make the right decision. They're going to acquit these young men because the state is getting shellacked and I won't have to dirty my hands and nobody will have to worry about appeals. That's what I think is happening. And what else is happening is that they're not back. Okay, so that's my little 2 cents. That's what I think is happening. All right, let me see. I saw somebody. All right, I'm trying. Yeah, I don't think Judge and I'm sorry. I don't think Hilton and Love are on the same page. That's why I'm pretty confident they've not practiced together. They've not. One is out here doing lacrosse. The other one is bowling. I don't think they communicate with each other to come get together to play basketball. That's they look that far out of kilt. And I don't know what Atkins is doing. He might, Atkins might be the he definitely sounds like he knows what he's doing. I kind of wish they would let him be the lead because I think he would do a better job. All right, let me see. Al says, "Dear Woke Christian Gang, we'll see each other in the future, Rico. Remember, never, ever, ever talk to law enforcement." I mean, when you see it. Yeah, Love is searching for words all the time. And it never comes across as confident. It's cumulative. I think they got away. I haven't heard cumulative today. I've heard it today. It was big yesterday. Cumulative was the word of the day yesterday. And shenanigans. I believe the state will eventually mess up big time. They cannot ethically prosecute this case, in my opinion. That's fine. If to double back on what I said, let's say my fighter example. If a fighter keeps getting fouls, the ref does have to call the fight. You do have to call the fight. If you poke a boxer in mixed martial arts, if you deliberately poke them in the eye, or you kick them in the groin, you can automatically be disqualified and they'll be given the victory. That being the case, they need to have that kind of egregious air. It's not just like he scratched me or he's looking at me. It's got to be something egregious. So it is very possible, though, no question about it. But it is on the state to mess up. Okay. So we watch YouTube ask me to tell this story again in terms of Batman, and YouTube knows I like Batman. So let us continue. Let us go. So Bruce Wayne is, of course, the billionaire philanthropist and Batman's alter ego. He is dealing with the rogue gallery of rogue galleries. He has the best rogues gallery. So I'm going to pull out one of the ones that most people know, who is the Joker. Batman is beating the Joker in every way, shape, and form. Physically, mentally, financially, he is superior than the Joker. The problem is the Joker always has one trick up his sleeve, which is he's unpredictable. Nobody knows what he's going to do. He could come out of left field and do something that totally makes no sense. And therein is his power is the fact that he's erratic. So Batman oftentimes has to think as a lunatic in order to be to best the Joker, because it's not just a brute force type of situation. Put my hand to your face, but no, rather I got to put my brain and try to figure out how to think like a lunatic. And so therein is the problem. So the defense here has to think strategically, how do I operate like an unprepared lawyer? Because that's what we're watching. We're watching an unprepared team prosecute this case. And I believe if Brian Steele and the rest of them thought as unpreparedness, they could, and I think they actually are, in my opinion, they're aware of the unprepared things that the state is not doing or the state is not prepared, so on and so forth. I think that's why their argumentation is so crisp and to the point, even though Brian Steele can get wordy. I think that's because they realize that we know where you're weak at. And that kind of lends itself to a discussion about, political campaigns, focusing on what your opponent is weak at and maximize that, or what they're strong at and take it away from them, that kind of thing. But that was it. Thank you. this is just my little 2 cent, Pedro. I could be totally wrong. She could be bought and paid for, but that's what I think is happening. She wants to be, and we know this is not a secret. She wants to be a Georgia Supreme Court justice. And, you know, I think all things being considered, she probably qualifies to be one. I don't know all the ins and outs, but what I do think is happening is she doesn't want an acquittal of this caliber on her record. And it seems like she usually brings cases to their conclusion. So I think that's what she's doing, in my opinion. Yeah, right. Unless you can guarantee mistrial with prejudice, so double jeopardy applies. Otherwise, I hate to say it, just take it on. I just want them to speed it up. I want to get this thing on to, it should be done by Thanksgiving. Like, let's get it to Thanksgiving. Come on. But I really wish she would have at least turned the screws on the defense, on the state, and required them yesterday to be like, okay, we got 30 witnesses. No, you're going to slash that down to 15, and you have exactly 18 days to get this done. Let's go. That would have been magic. You know, debate is a part of law school. President Firstborn wants to be a lawyer, and she's a debate champion. And she's met with lawyers, she met with judges here in Georgia, and so on and so forth. And she's excited about it because she's really good at debate. Now, granted, she thinks that she's good at debate, and she'll try to bring that stuff onto the house. I'm like, yeah, leave that at the mailbox, because that doesn't work here. But I don't know what Love and Hilton have experienced, because I don't think that they're demonstrating that they're good at it. The state can appeal if, they're back. Let's go. Is it muted? Is it me? Hope I didn't do it. They haven't turned on the mics. Oh, Harvey's back. Bruce Harvey's back there. There we go. Mics are on. Maybe.
The next one, Your Honor, we are going to, I believe it's included in your honorable court's ruling. It's approximately 1:2539. Detective Gaither asked Mr. Kendrick how long Mr. Williams was in Miami, and he answers a couple of weeks. So I assume that your court said that that's not inculpatory, so I'm moving on.
All right.
The next one it's a visual. So if they're not showing the video at this, it won't matter.
All right.
But Detective Dennis points to the photograph of Mr. Stillwell and says he's all about that action, and they're talking about shooting people. They're talking about violence. So you may have to hear that, but and see it, but we would object to that.
You're not going to use that. All right. States agrees. Well, they don't agree it's Brutin, but they're not going to be using it.
Okay. The next one is Detective Thorpe. It's a 1:33:55. Mentions Mr. Williams and how Detective Thorpe heard that people went to Mr. Williams' home after the killing of Donovan Thomas. You may have ruled because of the way you treated the rental car that's not Brutin, but that's what I flagged.
All right. Do you think I need to hear it, or is it pretty much?
That's pretty much it.
Okay. Yep. That would not be Brutin.
The next one is approximately 1:43:20. And I'm not so sure this is covered by Brutin, but Detective Gaither asked Mr. Stillwell if he drives a Volkswagen, but I flagged it. But if that's not directly inculpatory, I understand that, but that's what is said.
Okay. And this is just, does Mr. Stillwell or his nickname drive a Volkswagen? Yeah.
Yes. The next one is 1:47:18. Detective Gaither asks what was in its, I say Mr. Williams, but Thug's demeanor when he pulled up to the McDonald's, and Mr. Kendrick said he cannot speak on that, so I assume that's not under this court's, honorable court's ruling, anything we deal with Brutin, so I'm moving on.
Okay.
And if I'm waiving
No,
something, you
you
say
are,
no.
you are correct
Okay.
in your assumption.
And then the next one is 1:48:07. Detective Gaither asks, so that night, meaning the killing, you didn't meet up with Mr. Williams, and then asks the same for Mr. Stillwell based upon your honorable court's ruling. I believe that when we're going to skip, and if I'm wrong, please tell me I'm wrong, but
Does, what's the state's intention with regard to anything you might ask about that?
Given his alibi, we would, well, I don't know what it, we would probably be
Asking that? Okay, well, yeah, I mean, I think that would be okay.
and then the next one is well, it's really the same, Your Honor. It's clarifying the same thing. It didn't meet up with Mr. Williams or Thug and Mr. Stillwell, so
Okay.
that's it.
Yeah,
That would
same.
cover the entirety. Now, that's just for Brutin, but again, I will send to this honorable court, and there are cases on a RICO conspiracy, a conspiracy, and Brutin.
Okay, I'll be on the lookout for that and the state's position on that also. All right, so we can circle back to going through the evidence that's going to come in with the next few witnesses, including Mr. Sprinkle. If y'all are ready on that, we can move on to the wiretap evidence that the state intends to use. We can.
the PowerPoint maybe is.
I mean, we can do the PowerPoint. Would the wiretap evidence come before the PowerPoint?
No, it would
Okay,
come after the
PowerPoint. All right, yeah, we can look at that. So everybody should have the kind of revised PowerPoint, I guess, that the state provided over the weekend, I think.
Easily run through it.
Yeah.
And Your Honor, if I may just turn my back, you will give a thumb drive to Ms. Winfrey. Yes.
And so what the state sent over at this point would be, y'all have taken out everything that you don't intend to use. So the hope is for y'all that all of what you provided is usable, and we'll sort that out. All right. Yeah, so if somebody wouldn't mind, I guess, just giving us kind of a slide by slide. And I don't know that it needs to be displayed on Zoom as long as we're all looking at the same thing. That might be a better approach. So let's all just get our email.
Move it along. Move it along. I
send
like it.
over and open it up and look at the slides on our personal
Oh, but that means we won't be able to see
or
it.
laptops.
It was sent Sunday at 9:15.
Right. And was it a Dropbox link or was it an attachment?
It was an attachment with a PDF.
Okay, right. Okay.
Okay, so I don't know if we're going to be able to see it, which is going to be interesting.
All right, is everybody ready? Everybody got it up? Yes, yes, yes. Okay. All right. Slide one, I don't see how the state could possibly need that slide.
No, that's not, no, I mean, it's not.
Okay. Slide one's out. Slide two. What, this is just sort of,
These are identifiers that APD has identifiers that APD has identified, and
all right, hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes.
Okay, so that one's out too.
If you say it is, it is.
Huh?
And
I mean,
just to make sure we're all on the same page, what you're referring to as slide number 2 is the picture that has an arm with a
Yeah.
tattoo. Okay.
Yeah.
Which also coincidentally is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All
looking
right.
at the title page. And then
Okay.
we're on the same page,
All right.
literally.
Okay, good. All right. Slide number 3. What's y'all's argument for needing
Shout out
that?
to Adam Abati showing up in the courtroom.
Because we've still got some language on all of this too.
So we can take out, we can take out all the language.
Mm-hmm.
We can take out all the language.
Okay.
Yep. Can you take that outside? John, may we be allowed to remove the Mondo board, the IT department?
Yes, that would be wonderful. We're not going to use it, so out it goes. So y'all go ahead and, yeah.
Not right now.
Okay. What about these 5 pictures?
So the pictures, Judge, are just as he's talking, he would.
All right. So who are I see we've got
Defendant Williams.
Mr. Williams, Rich Homie Quan.
Rich Homie Quan.
Are there pictures already in evidence of
Yes.
those 3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is Defendant Williams. And the dispute, the war,
Okay. I mean, is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Hold on one second, Your Honor. We have videos of the groups of
All right,
persons
so you could do
together.
a still from a video.
We
Okay.
can.
All right, how about slide 4?
This is just, Your Honor, in our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that there's.
Is there a picture of Mr. Watts in evidence?
Yes,
But
there
they're
is.
demonstrative.
Look kind of similar to this?
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something.
What are you talking about? Come on.
Or
no.
on something other than proof of the crimes we have listed in the
Are
indictment.
they gonna, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes.
it's gonna be crucial for the jury to see, here's Copeland and here's Watts?
Not crucial. But he will be talking about a specific interaction, specific.
Okay, well, he can
antagonistic.
talk about that without this, and if you need to like have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that.
Do we have pictures already in evidence of that?
No.
Okay, then this one's fine. Slide 6. With the stack of money and obscene gesture.
Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watts. So
Okay.
We've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've had a video
All
introduced
right,
of him.
well, don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June. However, that was after 3 o'clock. And so we did not enter
Ah.
it again
Okay.
this time around. So I do not believe the video is in evidence. I'll double check,
Okay.
but I believe that was after
All
3
right.
o'clock.
Actually, good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts,
The flashing of the large sums of money.
not the flipping the bird.
I mean,
Yes, no?
the flipping the bird, I mean, it wouldn't have, our argument is that it's relevant because it shows Mr. Copeland with that huge stack of money that we're talking about, and it makes.
Is this the night of?
It's.
Or
He
is this
walk around
just
that
the
money all the
night of
time.
The
Donovan
night-
Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a
Flipping the
bunch of
bird
money.
and holding money.
An exemplar.
It-
Good
it's-
word.
I think it's January the 8th. The 6th, January the 6th. So it was the night, it preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody J was punched out.
So this
He
is a
stayed
picture
flashing
from the
money.
night that, it all got shot up or
I'll-
something?
I'll confirm, but that's what
After-
my understanding, that is January the 6th.
I don't know it's January the 6th.
They're gonna get thrown out.
I don't know, maybe they know what he was wearing to the club
The
that night.
detective that gave it to us, so.
My recollection.
Oh,
is
you
that
can't
this
use
was
money
proposed,
when he wore it.
on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night,
We
that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just.
here's what we mean about flashing money.
No, the large amounts of money.
Right.
I think during the course of the interviews.
large amount of money that y'all
the
wasted.
jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money, did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So, the relevance bar is, of course, as the court knows, is a low
Yeah.
bar, and the fact that he's sitting there with that.
Okay.
What are you doing
he
that right
also is
now?
Flashing the bird though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So
He forever
maybe
doing
there's
that.
why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when we've got some more.
Yeah,
info.
Fonny got cash. Ooh,
All right, slide 7.
Finally got cash all over the place. What
This
are we
just
doing here?
shows a couple of the,
I don't even doubt it. I wouldn't even
the
doubt it.
Metro, but y'all, there's been testimony about the Metropolitan, right?
TIG Studios that
Right.
Mr. Copeland is alleged to
No,
have
I
shot
didn't.
up, or the believed to have
Oh man.
shot up.
We've had a number of crime scene photos ended of the Metropolitan. So there are a number of photos of that in already.
So it doesn't,
Cumulative.
there's nothing, if Detective Dennis is talking about this, putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that
Yes, he's a rapper.
orients the jury, that is helpful to the jury, that is substantially similar to what that is exactly what he's talking about. So there's nothing that should preclude
Okay,
him
and
from showing it to the jury.
TIG is who's,
Think It's a Game
Right,
is the company that Rich Homie Quan was
Rich Homie Quan.
under. That Think It's a Game Studios is inside
Right.
that building right
okay.
there.
This one's fine. All right, moving on to slide 8.
No problem. No
So
problem.
this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial, we'll always remember you part of
Club
that.
Crucial.
And, you know, the language about whether he's a high-ranking member of a rival gang, I mean, that's,
It can come out.
thank you.
But yeah,
I know it's asserted that he is, but this sets it forth like
yes. It's
fact, and that's for the jury to determine.
Yes, John. I'm just trying to X over everything.
Okay, so,
Did you have something?
I mean, those 3 pictures basically of Mr. Thomas and some of his
Brothers, family.
Well,
whomever.
I would object to the pictures of,
Agreed.
well, the pictures period. I mean, I don't know what the relevance is and what a jury would need or how this would aid the jury in understanding any testimony from Detective Dennis to show pictures of him and various individuals just standing around.
So, do you want to elucidate us on that?
Yes, we can take.
Okay. So they won't use that one. All right, slide 9.
So slide 9 shows just the type of
Are these actual posts already in evidence?
no, we did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if you want to enter those as examples, we can talk
Okay.
about that, but
Okay.
otherwise he can just testify that here's what happened on social media after the death.
Okay.
All right, slide 10.
Your Honor,
Yeah.
I would be objecting to Detective Dennis saying this is what I saw on social. Okay, you understand that.
Okay.
It would
and
be hearsay.
because- And how would, well, no, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted. And the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is is the evidence itself, not that it's true. This death to the big homie sent the word out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
Were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes. There were public threats, social media posts, and the like. And these would be them.
Okay, well, that would. Okay, and that would be overruled because it isn't being offered for its truth. Okay, but we can just do that at the point in trial. We don't have to have this slide.
Okay.
So it slides out.
Slides out. All right, slide 10. Tell me, I guess, what I'm looking at and why he's going to be using this.
So I think we can take this out. I think that this picture is already in any event.
All right. Slide 11. There's a lot going on this slide.
There he is. He can testify about that. It's basically Mr. It's the services of the victim in this case. So he can testify about it.
It's a good question.
Victim impact.
What would be the relevance of how, many people were moved by his death?
Judge, if I may come back to the court on that, I can take out the slide and as to the questions about it.
All right.
So 11's out.
So the slide, yes, 11 is not going to be used, and she'll get back to me on the relevance of how crowded his funeral was.
He's very loved.
And maybe it is. I don't know. But all right, slide 12. So how about slide 12?
We can take out that. It's a similar one as the one earlier, so we can take out we can take that out in the same way and introduce it if we need to.
Okay. Thank you. Is the picture with the placards from obviously some shooting already in evidence?
I don't think this particular one is, but it will be. We anticipate that this will be admitted in evidence.
Well, if you want to present it to him and ask him about it, that's fine.
Okay.
And the second one on there, do y'all intend to have him talk about that picture?
We can take that out.
Okay. All right, so then 13 essentially won't be used, and you can, if he can identify what's the crime scene photo, then he can testify to that. Okay, number 14.
Do we? So, Judge, we don't have to, with number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay.
We would, as opposed to using it as a demonstrative.
Okay, and I mean, if they're already in, then obviously if he needs to testify to them, he can, and if they're not in, you need to be able to, obviously you need to be able to lay the foundation.
Right,
but-
and we may just get, some of the ones that are as the court has already pointed out, some of the ones that are already in and put them on, just to use those as our exhibits with
Okay.
him.
I mean, presumably this shows everybody's, the relation, interrelation of these three people.
It does. He testified about that. But this is just like putting faces to the names and sort of family diagramming, and I think we actually did that earlier. So it would be referring back to something that's already.
I'd be objecting.
Then,
Your Honor, the mother, if I interrupt, I apologize. If the mother of Mr. Thomas testified to family relations, the father of Mr. Thomas testified to family relations, and Detective Dennis testified. Now, he may not have, actually. He may not have. So definitely the parents, the mother and the father, I would be, it's just repetitive.
Okay, sounds like she doesn't intend to use this anyway upon further reflection. All right, slide 16. We still have a current intent to use this slide.
We cannot use 16.
Okay. Okay, 17.
17. We can as well not use, so what, I think that what we'll do is just take some of the pictures, photographs that we've already admitted.
Okay.
And use those as exhibits rather than trying
Okay.
to introduce whole hog. This
Sounds
PowerPoint.
reasonable. So 18. Y'all still want to be using that?
No, we cannot.
Okay.
We cannot. use
All
it.
right.
Well, except that I think that the photograph in the bottom right corner
Yeah.
were guns that were recovered. But I'll confirm with Dennis. I won't need so that might be something that we could use as an exhibit and not a slide. So if there's anything in this picture, certainly not the top three.
Okay.
But if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it in on a demonstrative slide.
Okay. And these are all
It was the stuff that was collected from one of the vehicles.
from an alleged rival gang.
Yes, after the shooting at 1006 Hill Street. Actually, not the rival gang. This was the one that was collected from the people who.
Guys, I'm going to change it to a louder feed. I found one that's much
Okay.
louder. So I'm going to change it. If you
Well,
just
I
give me one
mean-
second. All right, here we go.
Bottom or
Yes,
okay.
the one on the bottom. Part of that photograph is part of what was talked about in the interview with Mr. Copeland that has been shown to the jury so far. So we could definitely take out the words. We'll do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
Okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe we should. I was going to say, rather than introducing the whole thing as just, here's his demonstrator that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're going to use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted or
Okay.
that we tender through
Okay.
him.
All right. And so that'll be true for the rest of this?
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, so she's just saying it's gonna be easier not to, because I mean, I would imagine he's probably kind of like press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right, so then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, you know, if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine. Otherwise, I guess we'll just see what happens at trial.
Your Honor?
Yeah.
Wouldn't the same rule that your court said the state now will give us what they believe they're going to introduce as an exhibit through Detective Dennis, and we could raise it with you?
Yeah, that would be helpful. I mean, you're going to want to take a look at this and then decide what you actually want to use. So once you kind of narrow that down, if you'll just let the defense know which ones you actually want to use, then they can raise any kind of objections that we could get taken care of outside of the presence of the jury beforehand. That's fine.
So
Thank you.
Can I just make an observation?
Sure.
Or an objection? So before this honorable court took over, there were lots of objections as to, it was Detective Dennis allowing to say his investigation. So not a witness came in, the crime lab person didn't come in, just he was allowed to say, I learned of, and these CAD reports, I objected to everything on confrontation clause and hearsay. And the former judge denied it. So it all came in. I think the state, is about to do the same thing with the same witness. And I will be objecting again. And I also have this section. I'm looking for Georgia cases.
Okay.
It says, this is, I have a couple cases. This is United States versus Wynn, Nguyen, F, that's wrong, 504 F 3rd, 561, 5th Circuit, 2007. Thus, while summary witnesses, which is what I call Detective Dennis, may be appropriate in complex cases in certain circumstances, they are improper for introducing evidence that the jury has not previously heard. We repeat our admonition that the government may not use summary witnesses for inappropriate means. While such witnesses may be appropriate for summarizing voluminous records, as contemplated by Rule 1006, rebuttal testimony by an advocate summarizing and organizing the case for the jury constitutes a very different phenomenon, not justified by the federal rules of evidence or our precedent. So to me, this is what I call a summation or a closing argument. And I know that the court struck it, so I don't have the same exact situation as my motion to exclude this, but this whole thing is a closing argument. This is PowerPoint was a closing argument. I understand it's no longer like that. It's dismantled, and now we're going exhibit by exhibit and rulings. But my point to the court is if you can just, I'm not asking for an advisory opinion, but this is going to be, there's 2 Detective Belknap, 1 Detective Gaither, maybe 2, but 1 Detective Gaither, I remember, 1 Detective Dennis. They've all been over objection, qualified as experts. They're on the exact same situation. And now we're going to replow. Detective Dennis already testified as to the alleged back and forth. He already said all this.
Okay.
So did Detective Gaither. It's all over objection, but I would object that it comes in now again.
All right. And what would be, what's he going to be talking about new? Why are y'all presenting him again?
So because he's sitting through some of these, specifically some of the interviews that we were
Okay.
talking about, some of the actual shootings that we're showing the evidence of, like on April the 28th, the Hill Street shooting, he touched on them. We did not get into, like, he as an expert talked about what their investigation led them to do and sort of what their investigation entailed. He didn't talk about the details. We won't be getting into rehashing something he's already talked about. The stuff that he's going to deal with now is going to deal with specifically the interviews that he conducted, depending on what the witnesses say. If there are some instances where, you know, we don't need to play the interview because they say exactly what they said, then we won't do that. But we're at a different part. He is a fact witness, and he's still he has still been qualified as an expert by the court. So we won't be rehashing stuff that he's done, and we won't be using, I'm not certain when Mr. Steele says, you know, he objects to summaries. As experts, they're allowed to talk about how they arrive at certain conclusions.
Yeah, I think there were maybe like a couple of different objections in there, but it sounds like one of the objections or potential objections would be if he's going to get up and basically rehash the same thing he already testified to about how, you know, the theory is that all of this came about because it was the culmination of, you know, some gang wars, basically. That's already been covered, so he should not be testifying to that again.
Right, we don't need to, but specific, like the April 28th shooting, the Hill, like we haven't put up all the evidence in some of them.
Nobody in here is being charged with that shooting, right? That's part of the story of some of the crimes that are charged in the indictment, right?
I think the court is saying that they are overacts. Some of them are overacts that are listed in the indictment. If that's what the court is saying, the answer is yes.
Okay. So I may be thinking of the Hill Street shooting as something other than what it really is.
The Hill Street is not. The Hill Street is not.
Right. That's when Woody and his girlfriend get shot at, right? Or no? Okay. All right. Sorry. There are a lot of shootings that I haven't been in this case the whole time. So, all right. So, but I guess, so let's take, for example, that one. I mean, we're not going to need to get into the nitty gritty of that one, because that one, all that we need all for the jury to know for that is it happened. Some people believed it was a rival gang. It, you know, made the beef worse. We don't need all the details about how many bullets were found, right?
That was free to read. That was Lucci's mom. And so
well, that was another one. But
so the overacts connect that shooting with the ballistics from that shooting.
Okay, so for that reason, that might be relevant.
And Lucci's a central sort of opposition figure in the whole.
Well, I guess I'll just have to take them as they come, but we do not need a whole entire like crime lab. But here is, you know, what you would put in if you were the state prosecuting that shooting, when that is not an overt act and it is just something that happened along the way that's part of the story. I don't want us to be having a mini trial about that.
And we've scaled back everything in the indictment, even like we were saying yesterday with the Rodelius Ryan murder. We've scaled everything down like that. So it's not to.
So are there other objections encompassed within what you just said, Mr. Steele, that I need to be addressing?
I don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab, a weapon that was used in this shooting and another shooting. You know, to me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements in the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation.
that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and bringing in the witness, or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was over objection. Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall. By September 2014, there were no witnesses here.
Okay, well, I mean, that's the subject for cross-examination then.
It's hard to cross when I have no reports. I have no reports. I have no expert report. I don't know who to interview to say, no, that's not true. I never told them that. In fact, I told them something different. This is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to reduce it to writing. This is all confrontation clause, and it's all coming in as a conduit through some, quote, expert. And it comes through with many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able to undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of y'all in court that there aren't expert reports. Does that continue? And y'all were going to circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been conducted?
For police reports, yes, we were actually. I think the court told us to do it for a specific act, and I can't recall which one it was, and we did. And there wasn't, but we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
yes, and
And that
you
produced
did.
nothing?
No, we have
Okay.
nothing that we haven't turned over because what we did, what the court required us to do was, it was for a specific one.
I don't think it was.
Hold,
I mean, it may have been for a specific one and then everything else. But anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So, no.
I'm sorry. Okay, I apologize. Mr. Atkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes, we don't have anything extra. We will go back again because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that. Yeah. And so with regard to the gang experts, did y'all go back and say to somebody over at APD and in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I know, but then I ordered you to. So did you do it again?
Okay, so
because I ordered you to.
We have not inquired a second time, and I apologize to the court. We're gonna do it again. I will do it.
I pretty clearly told you to do it again.
That's what he's reminding me.
That is
Yeah.
inappropriate, is what that is.
that.
That's not doing your job,
Yes,
is
Your
what that
Honor.
is.
I'll go make a phone call now.
Okay.
I'll do Love's job for her.
It came out during trial, during a motions hearing, that there is what I'm going to call a black book. And it's all the gang information. And okay, you seem like you know about it.
I've heard about this before.
Okay, well, I don't know about it. And we were told, we were given the Heisman. We were told that we're not getting that. Detective Dennis said he no longer works at APD, so he has no access. Detective Gaither said the same. Detective Belknap, who continues work there, says that's not for public information.
Well, I would imagine it is not. However, if such a thing exists. Do y'all know what Mr. Steele's referencing?
If he's talking about what Detective Dennis said that he used in the beginning of his career as a law enforcement officer, where he collected information, I think maybe he called that maybe a black book. I don't know if he's talking about that or if he's talking about the information that they keep on gang members. I'll let him clarify, but.
All right. Do you know, Mr. Steele?
I'll take anything that has to do in any way with the testimony in this trial to either be able to go and interview the witnesses, confirm the witnesses. There was a lot of talk over objection. The policy of APD, how they qualify somebody as a gang member, it's self-admission, it's somebody else who's reliable, which say that they're in a gang, they hang out with somebody. All that's in this supposed book. I don't.
Okay, that's entirely different.
Okay, so you now do know what he's talking about?
No, that's entirely different. Detective Dennis talked about, and Detective Belknap talked about how they identify gang members and what criteria they use.
All right, is that something that is in
something
writing?
in a black book?
Well, whatever. Is it something in writing?
I think that the criteria, those criteria that they use, that is something that is a written sort of criteria. And I'll get that.
Let me propose, if that's easy to get and they don't have kind of security concerns with it being provided to the defense, then provided. If they do have security concerns, then it can be satisfied by saying, Mr. Steele and anybody else on the defense team, you can come look at this written policy, at 12 p.m. on XYZ day over at APD. That satisfies it also. So in some way or another, if there is a written something that is how they classify, then give them access to it in one of those ways, okay?
I will, and we will also check to make sure that we've not already given them standard operating procedures as it relates to gang unit.
Well,
and
obviously,
gang
if they've got
identification.
it already, then they've got it.
But in terms of being able to cross-examine the witnesses on specific incidents that they've discussed, we've turned over entire files relating to each of these incidents.
Okay. All right. It sounds like what Mr. Steele's talking about is the sort of policy that you just mentioned, that are the guidelines, the criteria.
I actually want the specifics of who they spoke with. They're talking about.
All right. Well, they may or may not have anything like that in writing.
Well,
and you can always just interview the detectives to ask them those things.
Well, I have interviewed the detectives, and they tell me that they're not releasing that information. They would speak with somebody. They'd speak with Brian Steele. Brian Steele would say that Keith Adams is not involved in criminal street gang activity. That would go into some sort of book. And they would speak with Carlton Matthews, and he would say that Brian Steele is in a criminal street gang. That would go in some sort of book. I'd like to see that, because they're speaking about, we corroborated this. So I asked on cross, who did you speak with? I'm not going to tell you. Well, why don't I have the right to know?
I don't know. Maybe they consider them confidential informants.
He never said, I don't think he ever said, I'm not going to tell you, Judge. I think
All
that
right, I'm not going to relitigate it. If it comes up again, we'll deal with it then. Okay. So I'm not even sure how we got on that. Oh, but Mr. Steele, you've said a couple of different times that you object to certain portions of CAD reports as being hearsay, and you were going to give me some law about that. And I don't know if other CAD reports are going to come in or not, but. Okay, well, provide it, and that way provide it to the state as well, because if it's clear law, then they can just redact those portions of CAD reports, which might need to come out as hearsay. Okay.
So I have KAMUSOKO versus state.
I'm sorry, start over. I just didn't get that at all.
KAMUSOKO.
Okay.
Versus state 362 Georgia Appeal. 276 footnote 3.
And what does it say?
868 Southeast 2D 252 2022. Says Camusoko makes no distinction between any particular statements and declarations, and therefore has abandoned any challenges he may have regarding particular statements or declarations. There is nothing for this court to review where the appellant has failed to identify precisely what statements he challenged. In addition, although Camusoko mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were inadmissible because the 911 operators or other persons writing down the declarant statements did not testify at trial. He therefore has abandoned appellate review of any challenge to the CAD report on this ground as well, and that ground is hearsay and confrontation clause. It's in Division 2 of that opinion, but I read from footnote 3.
All right. So, I mean, that doesn't establish that if objected to, it would have been an objection with merit. It's just saying, hey, you're raising it on appeal. You didn't raise it below. We're not going to deal with it.
But it's not right. But the
So,
CAD report
okay,
could
maybe
be
you could come up with one that instead of saying this is a potential issue, says, all right, here is the issue, and in addressing it, here's the law on that. Can you try to do that? Thank you. All right. Okay.
in this case in Division 2A,
All right.
where the footnote 3 is.
Okay.
And what the court said was it's admissible under an excited utterance of hearsay. It's
Yeah.
hearsay with an exception.
Right.
So
Okay.
my point is, some CAD reports they don't identify an emergency situation. So they're identifying a past event. So that would be a confrontation.
Okay. Well, then you'll just,
It depends
if you
on the
plan
CAD.
to make that objection to every CAD report, then give me the CAD reports
Right.
and I will make a ruling.
That's right.
All right, let's do that. So that can be on the agenda for tomorrow. Okay, thank you for clarifying that. I do realize that there might be times. I just thought y'all had some kind of blanket, this part of a CAD report is always out. And that is not what we have.
Right. It's like a
Okay.
911 call. It just
Yeah, no,
depends.
I'm clear now with what you're saying. All right. So we've done the PowerPoint. So I am going to give us another quick break, but I'm going to say, and I'm going to say this once, and I don't want to have to say it again. And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for another 40 minutes, just take the opportunity to use the restroom so that we don't then 30 minutes into court again have to take a break because now you can't hold it anymore. Okay? All right.
Go ahead and go.
So we'll have a little recess.
These are not little children, but that's how that's how part of them are acting. So that's how she's treating them. Even if you don't have to go ahead and go. Don't tell me the number that you have to do. Just go ahead and go. Hey guys, one of the dear woke first or second borns had to be picked up from school, so I'm filling in. I hope that's okay. Now is a great time if you have to go to the potty. Maybe you can go run and do that, but please leave the stream play and hit the like button on your way either in or out. Let me know in the chat what you think about this ruling, about how she's handling the prosecution today with these slides. I hesitate to say my opinion. I hesitate. Dear Woke's in the chat. He says, wash your hands. Wash your hands. Hand sanitizer is not a replacement for soap. It's a get you by. It's a get you by till you get to a bar of soap or a pump of soap. You're getting ahead. I am not even highlighting that. And then hit the like button. Yes, wash your hands and then hit the like button. We ain't trying to have all kinds of extra stuff on the like button. If you have to sanitize and then hit the like button, that's fine. Slide should have never been omitted. If nothing else, she should have went through the slides and seen the ones that she had no intentions of admitting and redacted them. But she didn't do her homework. Of course she didn't. And then she tells the court that she's done something twice, lies about it, gets caught lying. They even tell her, Miss Love, you lying right now. You lying. You lying. And mute man has to get up and run out of the courtroom to make a call to cover for her. That's just messed up. He was busy on Facebook. He had to get up and run out of the courtroom to make a phone call for her. Look, he was trying to find him a John Deere mower on the marketplace. Shameful, shameful. And I feel like Steele is on it with those case laws, and she is shooting every one of them down, every one of them. She's like, well, that's not really what that says. I feel like you're not exactly correct, but I'm not a legal professional. I'm not sure what's more embarrassing, the trial or the potty break instructions. Well, if this trial is going to February or March, let's just hope the potty break instructions don't get more detailed. Let's just crisscross applesauce our fingers and hope they don't get more detailed. Hey, she's talking like their kids. I'm going to do the same thing. Not busy on Facebook. He was on Facebook yesterday. I got screenshots. He was on Facebook yesterday for a long time. Look, you know what I could have said. He was on MySpace. Look, I said it. I had to say it. He was on MySpace. I never got the whole appeal of MySpace. You showed up. You're like, I'm here. Now what? I'm just here. Looked around. Evidence submission. That is a great question, Abe. I don't know. I feel like there have been several opportunities for the prosecution to do the right thing. Is it not a Brady violation for them not to be giving evidence over to the defense? I have friends that are lawyers that say some of it, yes, is, and some of it, no. But regardless, they are supposed to be giving all the evidence over to the defense, and they're not doing that. She's more engaged in the bathroom breaks than she is trial. Well, Mandy, too. Don't make jokes. Good conversation in the chat. Yeah. More possible Brady stuff due to come maybe after the judge told the prosecution to check again with APD. Yeah, I'm interested to see how that comes out. That might actually be something serious. That might actually be something serious. Oh, was he looking up their social media stuff? Okay, I'll leave him alone about Facebook then. Maybe. No, I'm just kidding. I thought so, Pink. I thought so. I have a real good friend that's a lawyer who says some of it she's seen evidence of Brady, some of it not so much. But regardless, it's all supposed to be turned over. Rolling evidence rule. I don't know what rolling evidence is. I thought they were supposed to put everything into a drop drive where they could all access it. Is that not what they're doing? That's what I thought was going on, is that they were putting everything into like a Google Drive. Look, here's juror number 5 checking in, because you know they don't get on social media. Yes, it is. I'm filling in while he runs an errand real quick. This is Dear Woke Christians channel. Welcome. Glad you're here. They are on a potty break right now. Don't ask what number they're doing. They're on a potty break right now. They should be back any minute. I seen people walking back in around the camera. I don't see how a team of 14 people plus whole task force, and I'm sure a few interns, how can y'all pull this case together? That's a great question. Hey, Jason.
What it do, homies? All right,
Great
so
conversation in the chat.
oh yeah, I'm checking it out. Yeah, this is my channel. This Mandy is holding it down while I go pick up my big girl from school. She had a staying for some interview or something she was doing today. Anyway, so I believe the rolling evidence, in my opinion, was really part of the problem, because Judge Glanville basically said that they can bring information as they're gathering more information. They're able to roll it out. They didn't have to bring it all in one big giant wheelbarrow the first day that they started pretrial. So that's what I think part of the problem is. I think they're abusing it. Now they're like, oh yeah, I'm rolling out something from 2015. Well, that should have been in them. Now, if you found something yesterday, that's different, and you brought it, that would be different. But they've been just rolling, and I think it's allowed them to be lazy. Just in my little 2 cents. Does it make sense?
Aren't they putting all the evidence in like a drop file? Aren't they doing that?
They're supposed to,
Isn't that how they're
yes.
sharing stuff back and forth?
That is
I thought
correct.
so. Okay.
But they're clearly not doing a good job at it. They're doing a really poor job
No, they're not.
of Dropbox management is lacking, shall we say. But let's just be
That's
honest.
so
This whole
easy to
case has been
do.
like this. I mean, really. But we will see. We will see. But thank you again, Mandy. I'm going to jump out of here because here she comes. I'm
Oh,
going to
sure. Okay. All right. No problem. We got this. The judge told Love all she has to do is direct them on what to do. I don't understand why she won't. Look, if she won't, then the judge will tell Love what to do. We've been seeing it. We've been seeing it over and over. But still can be choppy. I like Steele. I do. And if I'm in Georgia, that's who I want representing me. Don't get me wrong. But he can be choppy. Let's be 100, right? You're running for Atlanta DA? Okay. Well, good luck, Venom. I wish you the best. I don't know you, but I don't live in Atlanta either, but, grace and peace. The judge should have required Love to go through the slides and remove the ones obviously on. Yeah, that's what I was saying. How ridiculous. And there were ones that she didn't even want. She didn't even want in there. But she doesn't. I think that I think her mind shuts off at 5 o'clock. At 5 o'clock, she's like, that's it. I'm done. Boom. I'm not doing anymore. And she's going home and she's getting out the caramel and the ice cream and she's Netflix and chilling. That's what. Yeah, I think it's because the jury isn't there. That and Woody, I think, can make things kind of tense. Every time he says, I don't recall or whatever, I think it can make things tense. Love's husband's got to be solved. Oh, we don't know that. Maybe she just loves her husband, likes to spend every minute with him. The slides are trash. I haven't looked through them. Maybe we should pull them up while they're on a potty break, because obviously somebody had to take a minute. Judge is not being fair. Somebody said it in the chat yesterday that her thumb was pressing down on the side of the prosecution, and I wasn't sure exactly what that meant. And what it meant was she was favoring the prosecution, like she was helping them out. And I agree with that. I think she is helping them out. I mean, she's obviously helping them out. And I hate to say that about a judge. I think we saw that in the Karen Reed case. If you guys watched the Karen Reed case, she was, helping Adam Lally too. She'd be like, "Do you want to object to anything?" And then she would, shoot down the defense's objections and stuff. You work in a courthouse, I guess, with the prosecution. You know them, you see them every day, that you befriend them, but that doesn't mean anything. You're supposed to be unbiased. Yeah, this is kind of how I feel here. But who am I? I'm nobody. Great commentary in the chat. Appreciate it so much. And you think that she doesn't like this thing? I think she didn't, but I think she is either starting to or is really helping them. One or the other. What did you have for dinner last Tuesday? How about what happened 10 years ago? I can't tell you what I had for dinner last night. I'm just being 100. I don't know. And I definitely can't tell you what happened 10 years ago. I mean, I can tell you approximate, but I'm pulling a Woody. I don't recall. I don't know. That case was a mess. Megan. Yes, it was. Any of us could be Karen Reed. Remember that. When we get done with this case, we should dig into that. I'm trying to get him to. I know you, bet. Still not ready. Still not ready. And I don't understand why they didn't just delay it. If they weren't ready, they obviously took their sweet time to get ready. Why not just delay the trial? I think people would have had more respect for them had they been more prepared. No, Karen, no, not me. No, that's not what I meant. They happen. They happen. Yeah. Politics. Yes, yes. DeBoe, yes. Worst of the state today. But I have thought that in days past. Did anybody watch him in appeals court? Did he bring the house down? I was tied up and couldn't watch it. I bet he brought the house down. Do me a favor while we're waiting on them to come back. Do the YouTube things. The like button, subscribe to the channel, turn on all bell notifications. You might want to go up to the top of the chat, change it from top chat to live chat so you don't miss anything. All the YouTube things. He was brilliant, but I'm biased. I got to watch it. I really want to watch it. Who in the chat knows who Emily D. Baker is? Just put a 1 for yes, a 2 for no. And conversations with Emily D. Baker to maybe come on the show. Wouldn't that be awesome? These two talking about YSL together. I think that would be great. I love Emily. I think she's brilliant. She used to be a federal prosecutor in Los Angeles. She's great. Yeah, she is great. Oh, yeah, we've already talked about that. We've already had that discussion. She goes on several channels where she has to do that. Yeah. She used to be a she was an assistant district attorney. But yeah, she's ADD really bad like me. Yep, here we go. That was a long potty break. All right, back to slides.
I think we can move on to another task on our task list. Open suggestions, or I'll pick one. I know we still have to do the excerpts from the wiretap evidence, so that might be a good thing to turn to next. Yeah.
I meant to bring this up yesterday. We've been labeling the excerpts from the wiretap as potentially co-conspirator statements.
Right.
And I think the state announced that those wouldn't be coming in until investigator Viverito testified. What I meant to inquire about the other day was, I know that they've suggested that there are additional co-conspirator statements. I'm just wondering if any of those are linked with witnesses coming up soon.
Hang on just a second. Nobody say anything because our court reporter needs to plug in back up. Our court reporter's still rebooting, so thought you might have something that was not something we needed to take down. Okay.
Some research to do on our case tomorrow. So with Mr. Williams' permission and Mr. Adams' permission and the court's permission, I was going to do that at my office. And I will not be here tomorrow, if that's okay with the court. And Mr. Williams said that's okay with him. He could speak for himself, and Ms. Adams said that's okay with him.
All right, sounds good. Thank you. Okay, we're back up now. So I don't know if all of what Mr. Sharp said got on the record. Do you mind just reiterating it?
So, yes, I will. We put off, we suggested that the wiretap co-conspirator statements are going to come in through investigator Viverito, which would be later on in the trial. But I believe that the state has also stated that there are additional co-conspirator statements or alleged co-conspirator statements that are not part of the wiretap. And I was just suggesting if those involve witnesses that are coming up sooner, that might be something that we need to address.
Okay. Do we have other co-conspirator statements that are not the ones from the wiretaps coming in through to investigator Viverito?
So, since we won't be getting to the wiretaps until she's number 91, witness 91, in terms of, okay. My question to the court is, would the court allow us just to go in order of the witnesses that are coming up and deal with the buckets of exhibits?
Yeah, that's fine. And I think that's kind of what the defense might be trying to figure out is, do we have some co-conspirator statements that are going to be coming up soon? And I'm fine if it's easier to just say, okay, we're talking about co-conspirator statements now and tackle the ones that are coming up soon. That's great. Or if we want to go witness by witness through, you know, here's the evidence that's going to come in with this witness. I think either way makes sense, but let's do one or the other. So yes, it sounds like maybe there are some other co-conspirators or alleged co-conspirators statements that are going to come in soon.
Not any that are coming up soon.
Not soon.
The witness buckets would be the most. The next, Jamari Holmes is the next time that we'll have co-conspirator.
Can y'all all hear her?
I'm sorry, I'll get closer to the mic.
Okay.
Jamari Holmes's murder is the next time that we'll have that issue. And that's the one that we were discussing at the beginning of court with Your Honor and
Okay.
Mr. Williams and Ms. Abbasi.
Okay.
So the co-conspirator,
That's a little ways away.
yes.
Does that answer your question?
Sorry, it froze up on me. Here we go.
Do they have whatever the co-conspirator statements are, whether they're from the wiretap or a different source? Do they have them all?
Yes.
And have they been identified as potential co-conspirator statements?
Yes, Your
Okay.
Honor. For the most part. Just 1 second, I'm going to confirm one thing.
Okay.
Sprinkles folder have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there
Okay.
that we intend to use.
All right, I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified as that. Okay.
My expectations are correct.
I'm going to stop sharing and
The state.
pull your stream back up.
Have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there
Okay.
that we intend to use.
All right, I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified as that. Okay.
My expectations are correct in line with the courts. The state is going to specifically identify those alleged co-conspirator statements. Correct. I mean, there's thousands of jail calls from probably, I'm underestimating, thousands, yes. So we would need to know what statements, when they're made, between whom and whom, if the state, because we would like to litigate these beforehand. I know the court would too.
We put in the Mike Sprinkle bucket.
Can you guys hear that
jail
okay?
calls
Leave the
that
one in the
we're
chat for me.
using.
All right, so jail calls y'all intend to use are all in the Mike Sprinkle folder.
The ones that we, yes, the ones that we have identified that we intend to use, and those are the ones the court told us to.
Okay, so the universe has been narrowed, hopefully substantially. I haven't looked to see how
Okay, thank
big
you.
the Mike Sprinkle folder is, but
If it's the same one that I think they're talking about, it's about 200 calls.
okay, well, then,
15 minutes each. So that's 50 hours of.
okay. Which I presume is one of the reasons y'all said, let's hold off on dealing with what's in the Mike Sprinkle folders. So as the state, look here, as the state is itself going through the Mike Sprinkle bucket in further detail and identifies for itself the specific co-conspirator statements that it intends to introduce, please identify those as well to the defense. As soon as you know, let them know.
So we have 14 in the Shannon Stillwell folder. We could start there since that is his client, Mr. Shart's client, that we could actually review.
Okay. Let me get some clarity. So in the Stillwell file of jail calls, are those already identified? Just here are the co-conspirator statements, or are they just like, here's a 15-minute call, here's a 5-minute call? All right, and do you know what portions of those calls you? Yeah. All right, but whether you've broken them out or not, do you know what those are?
Yes, that's why we put those 14 in there.
Okay, so if you can, if that's what I'm saying, is once you know, here's call from January 2nd, that is 15 minutes. I'm going to use minute 2.5 to 2.9. That's the part I care about. When you know that, let the defense know that. Okay, so if you know that already, instead of us sorting it out here live, give that one of y'all sit there and type it up and send it over. They can look at it tonight. We can deal with it tomorrow. Okay. And similarly, do that for everything else. All right. Okay. So that it sounds like the most productive thing to move to next, unless somebody else has a different idea, I'm willing to listen, is to just open back up, you know, the witness folders and move on to whomever the next witness other than Mike Sprinkle is going to be, and go through that proposed evidence for any kind of evidentiary issues we can hash out now. All right, let's do that. Why do I hear something? Dropbox link we were working from yesterday. That is the Dropbox link of the first 30 witnesses. So if everybody can find that again. Bless you. It's not easy to find it because sometimes instead of y'all giving each a new reline to your email, you just tag on to one that already existed. Gotta get to it. There are many, many different things to build.
Eighth, 2024 email from Mr. Atkins.
I'm pretty sure that's right?
Yes, Your Honor. It says 30 witnesses, and then it has 8 August 24 in parentheses.
All right, y'all let me know when everybody's there. Is everybody there now? Almost. All right. I'm waiting on y'all to tell me if you're there. All right, is everybody there? Has everybody got the 1 through 30 Dropbox link up?
We have the full, Kendrick has the folder. We have the folder.
Okay,
I don't know about you.
great, thank you. All right, I've heard from 2 of 6. Y'all ready? Okay, 3. Stay ready. Okay. Mr. Matthews, you got it?
Yes.
All right. Who else? Are you ready, Mr. Sharp? Okay. Mr. Adams or Mr. Steele? Okay. All right. All right. Here's the one we're waiting on. Okay. You will catch you. Okay. All right. I think that we yesterday had gotten, other than Mr. Sprinkle, through. There was nothing with regard to any of the phone custodians, right? Sure.
Start throwing some stuff. Let's see you get angry. Let's see it happen. I don't think you're actually mad. I don't think she's really mad. She does sound annoyed though. But as you said, it's her fault. I had to take the show on the road, man. I had to take the show on the road, Greg. Don't call me out.
Sure. All right, so the question on the floor was whether there's anything we need to look at with regard to any of those 3 cell company custodians.
Your Honor, if they would like to stipulate, as to those records, we can just bring in the records themselves and save that time, but.
That would be nice. How about it? Miss Westmoreland doesn't want to.
Why not?
Okay, no, that's not going to happen.
All right, Miss Westmoreland doesn't like
All
it, then
right,
I don't
well,
like it.
so we'll have 3 more witnesses, but with regard to the evidence within those, any kind of motion and limine type issues we need to deal with on those. Thank you.
This is wild. This is just
Okay.
wild.
Then James Burney is the next witness listed. Do we need to look at anything with him?
That's true right there.
Expert from the FBI phone records.
Okay.
And this is one that I voiced an objection to repeating the testimony because Agent Racy talked about for a long time where the phones were located. The prosecution stated that based upon questions by some of the lawyers for the accused, that they needed to do something else. I'm still holding my objection because I believe it's going to be, I looked at the report, it's the same thing, maybe a little nicer because it was done nicer. And I don't mean to insult Detective Racy. He didn't have like a, a chart, but I just believe that it's the same. And by when the same, I'm talking about the April 26, 2015 shooting of the bus, tour bus of Mr. Carter, a performer known as Lil Wayne. Otherwise, no, I don't have any issues with with
Okay.
Agent Byrne.
All right.
And Your Honor,
Yeah.
per the court's guidance, this April 26, 2015, we are not discussing with Special Agent Burney this, when he speaks on specifically the January 10th, 2015 murder of Donovan Thomas.
Okay.
That's the only cell records he's going to be testifying to right now. He does analyzes cell site tower data for other acts in this case and counts. So he's one of those witnesses that testifies multiple times when that act comes up. So what Mr. Steele, specifically the April 26, 2015, we will not be
Calling him for that purpose?
correct, Your Honor.
Okay, but so when he's called here, it'll just be for the January 10th,
2015. Yes, Your Honor.
2015? Okay, anybody else? Nope, nope. I hear, all right, not hearing, but I'm seeing nods, no. Okay, all right, great. We'll move on to the next witness folder. All right, GBI Firearms, Voss in Wheatsel or Whitesell. Any issues on those?
My understanding is that these witnesses listed are the witnesses that are going to be called. Is that correct?
Mr. Voss is not going to be called pursuant to the information we sent to you all a few weeks, 2 weeks ago, maybe. Mr. Whitesell is going to be called. I believe there's on the email that we sent to the court and to counsel for the defense, the peer reviewer and the verifier for David Voss would be called rather than Mr. Voss.
All right, and is that peer reviewer / verifier Whitesell?
How do you become a
No, it's
verifier?
actually Vanna Kelly.
Vanna Kelly? Okay.
Yes.
Is that Ms. Kelly?
Yes.
Okay. Does she have her own reports?
No. Actually, what we're doing is getting the data, the underlying data.
Still getting
So she
data.
verified these. And so any underlying data that she has that they may want, just in case they want it, we have to get that for them.
Okay.
Still
It's
getting data on
unclear
a
to me
case 10
the
years
work
old.
That I guess Miss Kelly did on this case. It's unclear to me what the work she did was, but obviously, Your Honor, there's potential for confrontation clause issues involving Miss Kelly testifying to the results.
All right, I would presume, I mean, typically when they testify, they say, I ran all the tests myself.
Right.
And obviously, if they didn't, then that's going to be problematic.
Right, it would be. She looked at the evidence under the microscope herself and came to the same
All right,
conclusion.
so she will be testifying to her own conclusions, not to his
Not-
conclusions.
Right, hers match his, and he was the one that put out the report. She verified his by going through and looking at that physical evidence under the microscope.
Okay, but her conclusions will be based upon her own
Correct.
testing and observations.
And to my understanding, we don't have a report from Miss Kelly. If maybe she's not writing a report, I don't know, but I'm bringing it to the court's attention and state's attention that my understanding is we don't have a report from Miss Kelly. So if one was generated, we need that report.
That's what I was just saying. She did not generate a report, but her underlying notes and data, that is what we said we would get for them because her conclusions.
No,
She doesn't have a separate report, but she's got notes and data, and y'all will be provided that when? Did y'all have that yet from her?
No.
Why don't they
I
have it
spoke with
already?
the GBI last week and I'll follow up this week.
Okay.
Why don't you already
Let her
have
know
it?
that this is an ongoing trial and they need to
I will.
provide it ASAP and then provide that over ASAP to the defense. Okay.
Also, with respect to Agent Bernie, if we could swing back to that.
Sure.
He will likely
Amazing.
not be testifying until the end of September, in which case, any time needed, we believe, for the defense to review his analysis of the April 26th incident would have, we believe that rather than having him testify 2 different dates for those, for the incident here and the incident in April, would be obviated by the fact that he's gonna not be testifying until the end of September, as opposed to having him testify at the end of September and then come back 2 weeks into October. So I guess we're asking for clarification on whether or not he can just be brought in, whether that is not enough time for them to look at the additional reports that they were given last week, or was it last week? Week before?
maybe.
Week before last, right?
Okay, let's find out.
The issue isn't the amount of time that we had to review Agent Bernie's report about the April 28th incident. The issue is that Detective Racy already testified concerning the movements of cell phones. And and the state seems to be justifying this on some sort of cross-examination. That really the allegation is that Mr. Winfrey was moving with the bus, and the allegation, which I strenuously deny, is that Mr. Stillwell was moving with the bus. Mr. Stillwell didn't have a cell phone, so I'm not sure what the point of any of this is in the first place, much less hearing it for a second time.
Okay.
Read.
Yes, Your Honor. During cross-examination, they challenged Detective Racy that he was not an expert and therefore that he could not testify as to what side of the tower that the phone was on, only the tower placement.
Okay.
And because it was specific as to what side of the tower it was on, that's why we asked Agent Bernie to do the analysis based on their cross-examination. I think specifically Mr. Weinstein objected that because Racy was not an expert, he could not testify to what side of the tower that the phone was actually on, which is important given the movements of where the phones were at particular times, the evening or the morning of April 26th. So that's why it became relevant for us to get Agent Bernie to do the analysis, because he can talk specifically about what side of the towers the phone was on at particular times.
All right, which phone?
This was, so it was Mr. Winfrey's phone, also the phone that we're identifying as Dolly White or Max's phone. There may be about 3 or 4 other phones that I can't just recall off of the top of my head, but all these individuals were ascended upon the compound, which is where they started, and
Right.
followed the bus all the way up to the hotel,
Okay.
and then went down to the studio after.
Okay. And does anybody identify a phone as one belonging to any of these co-defendants?
Not.
Throw this stuff out. Judge Whitaker, just throw it out. It's easy.
I can't get this to go back to.
We can hear you, Judge Whitaker. Let it go. This is ridiculous. Out this data. Throw it out so you don't have.
Hang on.
Oh, sorry,
hang on.
sorry.
Yeah, this is wild. It says, I'm catching up. When is the black entertainers or their affiliates having money considered RICO unless you directly show that their money was tied to criminal activity? I mean, at this point, that's what we're doing. We're saying, again, are they reckless? Absolutely. But just because you have a lot of money and you're flashing
All right,
it,
go ahead.
really?
Only phone that he analyzed from these defendants here would be Mr. Williams' phone, because Mr. Williams' phone, we had that plotted that he was in Baton Rouge at the time of this, which was consistent with what some of the testimony.
Okay, so tell me why we need to hear from and we may, but tell me why we need to hear from Mr. Burney about the side of the tower that other people not on trial hear.
Because it's a part of the conspiracy, and it corroborates what other people said about the movement and where everyone was at the time. And because they challenged it so much that we can only say that this is where the tower was, but with no more information.
Okay, and was there testimony, whether there were cell phones for these people or not, was there testimony that X, Y, or Z co-defendant on trial now was with this crowd?
We believe that some testimony will come in soon that Shannon Stillwell, although we did not have his cell phone,
Right.
that Shannon Stillwell was present at the time of the, but it
Okay.
has not come in yet.
Okay, all right. So then, with regard to that incident, Mr. Burney's testimony should be on the narrow issue of, I analyzed these cell phones and I can say that it was this side of the cell tower. But we won't need, I would think, to go through, I don't know, but did Detective Gracie give sort of the overview of here's how we know all of this anyway, and here's what, you know?
Correct,
Okay,
yes.
so we won't have to go through all of that again. You can just cut to the chase of, yeah, I know all of that stuff too, and here's what else I know.
Yes.
Okay,
Yes.
that works. All right, so moving back to,
Can I ask you a question?
yeah,
Does that exclude then Mr. Williams, who's in another state at the time? We're not going to hear about that again.
I mean,
Am I correct?
are y'all gonna bring that up again?
Because that
Yes,
was
but-
testified
but-
to.
In the sense that he received that document and he plotted that as well. Yes, but we don't have to go into the details of it, but I think it's a part and parcel of what was happening that night
All right, hang
that
on.
they challenged.
Hang on. Did anybody from the defense challenge the legitimacy of Detective Gracie's conclusion that Mr. Williams' cell phone was in a whole other state?
I agreed with it.
Okay, then if there was no challenge to that, that shouldn't need to come up again. Right?
Can we ask him whether or not he plotted that phone? Because if he's going to talk about some of the records, we think it's important that at least the jurors know he didn't.
Yeah, I
didn't come
mean,
with the same-
yeah, if it's like that could be like a one question.
Yes.
Yes, and it was in somewhere else entirely, which I would think, Mr. Steele, at least you would like. Okay. Well, that part certainly wouldn't.
Where'd you send them to?
So you, okay. All right. That is what I said. Okay, so back to the two firearms examiners who are going to be Kelly and Weitzel, where we can move on from that. Silence is yes here. Okay, so next is Officer Zaffa. Looks like, is this one of the crime scene techs?
He's the responding officer to the January 22nd, 2015 shooting at 1007 Hill Street that we talked about earlier.
Any issues with this?
And you're right.
Mm-hmm.
I think it's actually Officer Z Atha.
Oh,
Yes.
okay,
And
there's no
I
space
changed it,
between
yes,
those
and
two.
and
Officer Alpha. Okay, thanks. Any issues on those photos, images? Are y'all just looking at these now? Okay.
My concern is I don't have any statements from any witnesses. I have the officer responding, but we'll see the next witness that you have on your list. We'll see if there's any more information that we're supposed to get.
we have the police report, Your Honor, that we've provided, and then we provided, at least for this one incident, will be Miss Reed, which is the victim in the case, and so that is what we intend on introducing.
And is there a statement of the alleged victim? That's what I was.
Her statements are reflected in the report, to the extent that she gave on site.
I doubt if they can hear her, that y'all is gonna have to pull that mic back over.
Her statements are reflected and memorialized in the reports that were written and provided to the defense.
Okay.
Just so we're clear, my understanding is that the allegation is her home was shot up multiple times. And so we do not have any written statement or any taped statement by any detective, taken by any detective, given by this alleged victim. And so that's what we're asking about. We understand that statements may be memorialized in a report, but we are specifically asking about tape statements, written statements.
Your Honor, we'll double check, but the answer be no. Whatever her statements is contained with what she told the responding officer and he put in his report.
Okay. And this was way back before body cam was typical, so that wouldn't be unusual. All right. If y'all find something else, obviously provide it, but no, that to their best belief at this point, no, there's not anything. You have everything that there is. Okay, so I'm assuming that other than that concern, there aren't any issues with these pictures that are included, since I hadn't heard any objections directed to those. Is that fair? Fair. Okay, thank you. All right, next is Sanders. I'm not sure what CST stands for, but
Crime Scene Tech.
Crime Scene Tech Sanders. Very good. Also lots of pictures and images of their walking through the crime scene and documenting it. And then the report. Any issues? All right, thank you. All right, moving on to
All right, let's see what they do.
Antrivia Smith. What is that, a video? Okay, any issue on that? It's a short video, so even if you're watching it for the first time now.
I hope not. I hope not.
I was under the belief that they were going to introduce this video through Mr. Sledge, but
All hang on, and nobody can hear across the courtroom if we don't talk into the mics. I know it's annoying, but.
We have it coming in through Mr. Sledge. That's why we were just pausing, because it's already been an exhibit that's identified
Okay.
as coming in through Mr. Sledge, but it was Ms. Smith who gave it to the police following the shooting of her apartment to show the antagonism that existed between Mr. Sledge and YSL and Mr. Watts, whom she was also seeing. So that's the reason that it's in both folders.
I would hope the questions are not articulated that way in trial, because it's Mr. Sledge arguing with another man over a girl. I don't know YSL how that fit in, but
I said, come on.
Okay, well, that may be, it probably will, and if it's presented that way, then y'all will have some good subject matter for your cross-examination.
That there's Mr. Sledge, since it was mentioned, Mr. Sledge said, oh, no, it wasn't over a girl.
Okay.
We weren't beefing over a girl.
All right, well, they'll say whatever they're gonna say, and y'all can examine accordingly. All right, Sharon Latner's. These would be the CAD reports, I assume. So we'll hold those for tomorrow. Does that work? Okay. And tomorrow, y'all can tell me what parts of, if any, of those y'all think might be excludable as hearsay without an exception. All right. We are moving now, at least theoretically, to a different overt act, I think, right? So now we've got crime scene tech Turner. And that folder is empty, at least for me. Do y'all have something in y'all's folders for that? They're empty for y'all too? Okay, well, maybe that was just a mistake. Is there supposed to be something in that folder?
Why is she like excusing it?
All right, we'll come back to that one. Y'all check on that tonight.
Really?
And that may have been the ones that they told us that APD no longer existed. It may have been the ones that we identified and told the defense about. There were about 127.
They're so
From the
organized.
hack from whenever
Yes,
that was.
we had asked them for the physical copies, if there were any, because they said that the digital copies did not exist.
Okay.
And so that, I think that those were, it was Turner. It was Turner's
Okay.
photos that were those
Mhm.
photos that we
Okay,
were trying to
those
get.
were lost in that several year ago.
But why is
It
she
sounds like.
why is
So
she
that's why
answering
that's-
for them though?
That's what the photo lab
Okay.
told us.
All right, moving to Jenkins.
Jenkins.
And these are just crime scene photos. Look pretty standard. Any objection on those that y'all anticipate? Okay. All right, Tyrone Dennis. All right, let's walk through it kind of one by one. All right, so the first thing is what's identified as States Exhibit 71, Act 78, and then the lyrics to Bad Boy. All right, what's our objection? And this is only if this hadn't already been litigated. If it has, it has.
Mr. Williams doesn't, these are not his writings.
Okay.
Somebody, Google, I was told Google, just put them down. I'm not telling you that they're wrong, but I'm certainly not telling you they're right. But it shouldn't come in this form. This is not how Mr. Williams made a song.
Okay.
So I would be objecting to the best evidence rule, and I don't know why. I don't know if the state is planning to hand it out as an exhibit to the jurors, flash it on a screen, but I don't believe that this is proper testimony. In addition to that, Detective Dennis, for him to claim here are lyrics and here's what they mean, I don't think he has any basis. I've asked him whether he,
Okay.
when he was qualified, whether he spoke with anybody with the lyrics, how he makes the lyric. He has no idea. He's just a listener.
Okay.
So those are all but those are, I raised those objections previously when we were arguing.
And, sorry, go ahead. And what?
And the court stated he made a preliminary finding, the prior court, that lyrics are admissions, confessions, co-conspirator statements, and if a proper foundation is laid, then he will decide later if they come into evidence. That's
Okay.
pretty much how
Thank
it
you.
was.
All right. So the best evidence objection y'all might need to deal with.
Your Honor, we would be, as far as the displaying or the publishing of the song and the lyrics to the jury, we would likely be doing it through Mr. Williams' words as he speaks them, and we may have a accompanying, it can be typewritten, whatever, transcript of the lyrics, however it is.
Why don't you have this
that
done?
we intend to display it, but that we can also provide to the jury in terms of their ability to more easily hear
As a
what is being said.
demonstrative aid.
Yes, and as far as the objection as to the meaning behind certain words or lyrics, Detective Dennis would be talking based on his expertise in certain areas, particularly as a gang expert, as to certain meanings or certain language. But if there isn't, if there's a different interpretation or if someone else intends it a different way, then we would submit as the area for cross-examination or a different testimony from the person who said.
All right. Well, I think that with regard to something being used as a demonstrative aid, you need to make sure it is the correct transcription of what the lyrics actually are. It does not need to be pulled off of Google. I mean, if you want to pull it off of Google, you can, but it doesn't need to look like this. And please provide it to Mr. Steele and Mr. Adams beforehand so that if there are any disputes as to what the words actually are, those can be dealt with. And then I would permit Detective Dennis, if he's been qualified as a gang expert, to say, in my expertise, this might mean XYZ. Obviously, it doesn't mean that is what it means, but that's his opinion of it, which the jury can accept or not accept. It's up to them. And of course, he can be crossed as to how on earth he might know that, and, all sorts of good things, I imagine.
I guess it depends on the lyric, but intention can never be discussed by an expert, a person's intention, because it's not beyond the
Agreed. I mean, yeah, I wouldn't let him say, here's what Mr. Williams meant when he wrote this lyric. Just this lyric in common gang parlance, we believe means whatever. Okay. All right. All right, the next is Exhibit 72. It's basically the same thing. It's just another set of lyrics. Okay.
Your Honor, one other thing when we're talking about these lyrics that I think I need to bring up right now.
Okay.
I believe that, we are going to be asking for a limiting instruction.
Okay.
I don't know how the performance of music I mean, the state is fighting us tooth and nail saying YSL is not music. So I don't know how that at the same time putting out music could be in furtherance of a conspiracy. So I would think that the lyrics can only be considered in regards to the person who is the source of the lyrics and not the other people sitting here.
Judge, I think that so one, we've never made the contention that YSL members do not rap. We have repeatedly asserted that there's that aspect of the game. So that's not true at all. And I believe that the issue of who it comes in against has already been litigated. I will make certain, looking at the order that Judge Glanville has entered, but there is no limitation as to this only comes in against Mr. Williams because he's the one that said it. It's not a testimonial statement. We would argue it's at the very least a co-conspirator statement, but and at times there are adoptive admissions, at times it's a party opponent, but there are various hearsay exceptions that allow these statements in. And Judge Glanville, we're looking at the order, but I believe Judge Glanville specifically ruled that they come in as co-conspirator statements. We'll look back at the order he wrote and entered after our very, very long hearing on this matter.
Okay, well, y'all let me know about that. And if y'all want a limiting instruction, you can certainly propose one and I will take it under consideration. And, you know, if it's a blanket, every bit of this is a co-conspirator statement, that's one thing. If some of them are one exclusion and one exception and some are another, I'll just have to look when I'm considering a potential limiting instruction.
And Judge, also, when we intend to enter certain statements made by certain of the defendants in that they have put a beat behind, we don't intend to play all of the words to all of these songs by any means. So we would we'll extract the words that we intend to introduce and make certain they're aware of those and tailor those to the order that has been entered in any order that rulings that the court makes.
Okay, thank you.
This has got to be the most insanest thing. Why is this stuff not done? Why are you bringing a case and you don't have this ready?
Down through 79, also lyrics.
A lyric, 79 is
so
a video.
Sorry, then 71 through 77 are all lyrics.
Yes.
Okay, so the ruling would be the same as to each of those. All right, so now we'll turn to 79, which I can't seem to open.
It's a picture,
right? Okay.
I can share it. Well.
Okay, thank
Want me
you.
to share it, Charlie?
Sure. Okay. Okay, it's already in. I couldn't hear you. What'd you say?
We believe that's in already. We agree.
Okay, Mr. Steele, did you say something about Brutin?
That's what I'm reading, but no, I said the same thing as Ms. Adams.
Okay.
I cannot be 100% sure, but I believe
y'all,
it's.
all right, well, if several of you over there think it is. And y'all think it might be?
The caption may not be.
Okay. Any issue with the caption?
Not 100% sure. I believe it's in, or at the very least, it's been testified to. But I guess when we find the original.
All right, y'all can let us know on that one then.
Judge, did we reserve on, or some of the 71 through 77 because we were going to check the order, Judge Glanville's order? I want to reserve on 74.
Okay, yeah,
And-
we did. We're gonna
Okay.
get the order and then come back to that.
All right, thank you.
Thank you. Suddenly.
Sadly, I think she is still at the beach. This is terrible, man. This is horrible. What have they done for 2 years? That's a very good question. So I'm going to ask, what have they done? How are you here and you're now still sorting through? Again, this case was 10 years old and you're still just sorting through it. This is bonkers. This is insane.
Sorry, y'all. Somehow everything got closed, so I'm opening it back up. Okay, so then next would be Exhibit 82. Is that already in by chance?
That's a
I
good,
don't believe it's
good
in.
call
I
out.
believe we've discussed it regards to another witness
Okay.
previously. I don't have any problem with it personally.
I believe we talked about this
I
picture
think we've
yesterday.
already dealt with this.
I told Woody he should have copyrighted that. He should have. But
All
actually, Venom, they are like us. Is a false claim.
State's Exhibit 83, what is it, Lima LL? Not that up on my native phonetic alphabet. I got it right. Lima.
All right.
What is, I mean, I know what this
This
is. but
trial.
What does this have anything to do with?
Your Honor, that is the, I believe that is the gun, yes. That is the gun that was found at
And
the
he got a gun.
Dunbar Center with Mr. Copeland.
All
in
right,
the
any
H&M
issue
bag.
on this?
Not if there's an appropriate testimony for it. So no, I don't anticipate any issue.
Okay. So I imagine, obviously, they'll have to establish that's what it was, but assuming that is established, that can come in. Bless you.
Listen, they are all over the place.
Okay, and then 84 Lima A. Any objection?
If this is this the black and white picture, Your Honor?
No, this is a video of a club.
So this is, Your Honor, September 30th, so the night preceding the October 1st overact with Mr. Kendrick and Mr. Arnold, where Mr. Arnold gets into a fight at Magic City. This is a video of that. And that's also 84, it's 84 LL, A and 84 LL.
Okay. Any issues? Evidentiary issues?
Not assuming they can lay the appropriate foundation.
Okay. So okay, LL is just a different view. Okay. So, and then there's another 84 LL
LL and then 84 LLA.
and then another 84 LL. Maybe that's a still? I don't know.
Let me see.
Oh, no, that's a gun. Maybe
okay.
there's a mislabel.
There's a
maybe.
mislabel, Your Honor.
Okay.
Mislabel.
Okay, so whatever that gun
How
is will need to
appropriate.
be
How
A
convenient.
different label.
a different number, but I assume that's some gun that's some way tied to something.
Yes, that's the gun, Your Honor, that was found on Quindarius Zachary when he was at the gas station.
Alright.
You picked that up, Bora Bora? See?
Then we've got 85 through 90 LL. Any objection to any of those?
One of them, we've already. So 85 LL is the interview of Mr. Kendrick.
Okay.
Yeah, and we've already dealt with
All
the
right.
PowerPoint, which is 86.
All right.
87 as well.
We've dealt with 87 already?
Yes. 'cause
Okay.
that's-
Oh, yeah, that's okay.
We've not dealt with 88.
88. Any objection to 88? Evidentiary objection?
I'm sure we'll be objecting to the commentary on this posting.
Well, except for the ones by Mr. Stillwell, I suppose, because so. Yeah, okay. We wouldn't have any problem taking out anything that Mr. Stillwell doesn't post.
Okay, yeah, I mean, that's gonna be done for all of these kind of Instagram-y type posts anyway, right?
Yes.
Okay. All right.
Instagrammy. That's wild.
Yeah.
Yeah, it really was.
If the state would educate me on the relevance of Mr. Stillwell's posting there.
Okay.
What
so-
they think it means, because I mean,
All right.
I'm not gleaning too much from it.
Okay, there's a relevance objection.
All right. So, Judge, we are alleging that Mr. Stillwell is a member of and a participant in a criminal street gang and a criminal enterprise known as YSL. His donning of these red bandanas, one on his right hand and one over his head, and his use of welcome to be that red bee with the red heart, Day Paradise, on March 28, 2015, during the year or the relevant time of this back and forth that was going on, are all relevant to the allegations made in the indictment. So with relevance being
Your Honor, I
the bar that it
misspoke.
is.
Hang on, don't interrupt.
I'm withdrawing.
Oh, okay.
I misspoke. I thought they were saying that someone replied to Mr. Stillwell, and I thought
Okay,
they were
no,
saying that was his
She's
post.
taking all that off.
Okay, all right, I'm good, thank you.
All right, thank you. I think that's 100% anyway, not a heart. Had to get my glasses out for that one, but
I
think the argument would be the same. Okay, so that objection's withdrawn.
Poor, look at Young Thug, man. He looks like what
Yeah,
in the
you just
world?
need with all of these to take off.
How
the
is my life
comments.
like this?
Same with 89.
Yes.
Any issue otherwise to 89 LL or 90 LL? Well, 90 LL is not a photo, it's a video. Any objection to either of those?
Oh, he's back.
Your
Sharp is
Honor,
back.
as long as they keep my client's comment on that exhibit as well, where he
Good.
sarcastically says we beefing, mocking the idea that there's gang rivalries.
Are we talking about 90 LL?
We're talking about 89 LL, right?
Okay.
I don't actually see that.
He doesn't say his client says
That would be funny.
dripping through Cali with some real ends at Gotti with that red B. His client is not listed under the 6 comments that are going to be taken out.
Is there like some comment later that isn't shown maybe? Because I don't see it on this.
You're right. I think he's talking about, correct me, the first comment says at SB with the we beefing, but I don't think that that's Mr. Stillwell. That's
Okay.
the other person posting that she's beefing with him.
What's going on is
Mhm.
these comments are in dark blue on the black background, so I'm
Right.
only seeing the white. So I'm seeing my client commenting, we beefing, which obviously would be sarcastic. He's sitting next to his friend, but now I see the blue that Okoya having her way posted that, so.
Yeah. Okay. All right. How about 90 LL?
We'd be objecting to 90. I don't see I don't know what the relevance is of
Okay.
90
All right. There's a relevance objection to 90 LL
and 403.
and 403.
Judge, I think it's best if we just play this
Okay.
one.
Big B, Lil B, Slime, YSL, Crip Killer.
That's Mr. Williams's voice.
Based on?
Directing
Let's not interrupt each other, please.
directing this child to throw up these gang signs.
Okay.
So that's what we.
So are you going to have some kind of either somebody familiar with Mr. Williams' voice to say that's him or a voice analyst to say that's him?
We would have someone that we believe is familiar enough with his voice to say that that's him.
Okay, well, we'll see.
We have Mr. Stillwell, we're going to ask for a limiting instruction, if that's admitted.
All right, propose one, please.
On behalf of Mr. Williams, Your Honor.
Clearly
what
beefing is a crime.
The import of this. So I understand it's prejudicial because a person may think that a young child using what I would consider gang language with their hand signs
Mm-hmm.
may be inappropriate, but why would this matter here? The lyrics are coming in. Mr. Williams is constantly changing the letter B to, or letter C to a B. Like instead of Cleveland Avenue, Believeland Avenue, there's a whole bunch of lyrics that Judge Glanville let in. There are tattoos on Mr. Williams' body that has already come in that shows the letter B and alleged other supposed gang symbols. They have introduced, they being the court has admitted into evidence exhibits showing things like a green snake or an emoji with a B on it. I just don't understand why the child is an important part of this mission to find the truth here. And Mr. Williams' voice, I find it to be wholly prejudicial, and I find the probative value to be scant.
All right, let's hear from the state.
So, Your Honor, as the court is aware, the rules of evidence are rules that favor admissibility, and 403 should only be used in extreme situations. And Mr. Williams, not the state, bears the burden of showing when something is shown to be relevant, it's presumptively admissible, and he bears the burden of showing that its prejudicial effect substantially outweighs its probative value. And Mr. Williams has said nothing about the prejudicial effect of this video with his child, with Mr. Williams dictating to this child, throw up B, YSL, Crip Killer, which are all things that Mr. Williams has attempted to distance himself from throughout the entirety of this trial. He has asserted that all of this is, not real. All of this is, just a facade. And the more that the state is able to show to the jury that this is, in fact, not a facade or not someone pinning on Mr. Williams' designations that are not accurately pinned on him, then the stronger the state's case becomes. So our argument is that Mr. Williams has in no way shown that this video is substantially more prejudicial than probative.
All right.
Your Honor, with respect to Mr. Huey, we would also chime in on the 105 instruction, but notwithstanding that, Your Honor, can you hear me, Judge?
I can hear you. I don't think that's working, but I can hear you anyway.
Can you hear me now, Judge?
Yes.
So we would also ask for the 105 instruction on behalf of Mr. Huey, but notwithstanding that, Your Honor, this is extremely prejudicial from the standpoint of having a child hold up these gang signs and so forth and so on, what appears to be gang signs. And again, this is going to be one of those scant and cumulative aspects of a piece of evidence that if the court allows it to come in, it's going to be drug in for the sake of its prejudicial effect. Clearly what 403 says we can't do. So I would ask the court to take that into consideration.
Okay, well, I'm certainly considering the appropriate law. Yes, sir, Mr. Steele.
There's also another, I can't find the exhibit number, but there's a video that came in over objection that Mr. Williams is doing something similar, or someone's doing something similar with a child.
All right, why don't y'all get me that, and I'll consider whether there might be a cumulative issue here. But with regard to just 401, 403, it's certainly relevant, and I agree that it's prejudicial, which, case after case says most of the state's evidence is prejudicial against defendants. I don't think it's substantially more prejudicial than probative, considering part of the conspiracy they allege is preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating alignment to the enterprise and a willingness to engage in violence on its behalf. I mean, it's wildly probative to that.
And Your Honor,
I think it's cumulative.
We're also going to ask for a Rule 105 instruction on behalf of Mr. Kendrick. And we echo the comments made by the others.
Okay. Yes, ma'am.
We don't believe that a 105 instruction on this type of evidence is appropriate. It's not a testimonial piece of evidence, a testimonial statement. So we would ask that a 105 instruction not be given in instances where this is the evidence being presented. And we would also submit that Jeffery Williams is alleged to be the leader of this gang, and in having or directing this child and other children to do things like he's doing, he is, in effect, he's starting early and starting young. That is part of the state's theory in this case, that this gang recruits young children, and this is what it ends up being.
Judge, I think there's a piece of evidence that came in on, or we reviewed a child on yesterday, if I'm not mistaken, that we saw in an image. It was either posted.
Yeah, but I don't remember that being anything that the child was doing in response to somebody directing them to do it. I think it seemed like the child was, be happy to look at it again, because that's not specifically what I was looking at it for then. But if that's what y'all are thinking about,
Well, that's one at least that immediately came to my
okay.
memory.
And do you recall that child was doing that in response to somebody directing them?
I'm not sure if there was sound associated with that
Yeah.
particular
I
image,
thought it was
but it
mute.
was certainly at the direction of an adult, and then the child
Was it Mr. Williams?
I believe it was.
Yes, Judge, it was. It was the, one of the two videos that you saw on yesterday.
It was mute.
And when you
Okay.
listen to the sound, it's exactly the same thing. The child is being directed. And in fact, it's the same child.
Okay,
He says big B, little b. He doesn't say Crip Killer. He doesn't say YSL.
all right, that is not cumulative, if that's the only one that y'all had in mind. So that's, I'm overruling those objections.
I'll pretend like I'm surprised. They're gonna RICO in pre-K. They're gonna
I think that
RICO
takes care of that
in pre-K. Man.
witnesses exhibits, at least for now. Martinez Arnold. I see there's a plea agreement in that one also. Same grounds as before. Is there anything in particular on that one? I know there was. This isn't the same one we talked about before, is it?
No. Mr. Sledge.
Okay.
It will be similar ground. He's testifying, so why do we need a plea agreement? And the state wants to put it in, my understanding. And it would be continuing witness because it's a statement, and he could testify to whatever, and then he can get impeached.
All right, well, continuing witness is only about
Great
whether
question.
something goes out to the jury or not.
Correct.
So that's not relevant to whether it actually comes in or not. And then
believe
it's
so.
the state's intention to use this only if you need to impeach him as to something? Okay.
Correct, Your Honor. And if he's truthful, then we don't need to accept, if he's truthful, then we don't need to go and show and introduce this as an exhibit. And I'm assuming they're talking about the factual acknowledgments, not the,
I don't know.
not the conviction
I
itself.
don't know. Let's find out. Are you talking about the factual acknowledgements?
I am talking about the factual acknowledgement, and then there would have to be a proper purpose for the guilty plea, which there could be one, but I didn't hear it yet.
All right, is there anything about the factual acknowledgements here? Like, I know that last one y'all were saying, I don't think this person has any firsthand knowledge. Is there anything like that I need to look at in particular? Okay. All right. And so for these people, you just intend to have them admit they pled guilty? Okay, so this wouldn't be relevant at all unless they say, no, I didn't, or no, I never asserted
right.
that fact, or
So-
this would be,
So right, or that he was forced, or he didn't
Right.
know what he was doing.
right.
I think the certified conviction might actually be proper evidence. I need to think about that, but as far as the other stuff that they're
I
talking
mean,
about,
yeah, and you can certainly, I guess, tender that if you want to.
yeah. But
Not really.
the other information is only, as we said earlier, if someone isn't truthful on the stand.
Right, okay, thank you. All right, the next item in there, I can't open, so I don't know what that is, but if y'all can open it and you know what it is and don't have an objection, then it doesn't matter that I can't open it.
Your Honor, we're talking about the third one down?
I was talking about the second one down because I don't know what that is. The one labeled like NT Fulton CODA and then some numbers. Oh, okay. Don't know why I can't open it, but we've already reviewed
Poor
that
Judge
one,
Whitaker.
or no?
So this is a transcript of an interview with Mr. Arnold, and there is no need to enter this or use it unless we need to impeach him.
Okay, and I assume it's a certified copy that y'all would use if need be. I mean, I guess it wouldn't have to be, but.
It's not certified?
Okay.
You mean of the transcript?
Yeah.
It's not certified. It's just a.
It's a hallway conversation.
Say that again.
It's a hallway conversation. It's not-
Hallway
it's not in
conversation.
court.
It's a
not like it-
130-page transcript of a conversation.
What?
Oh,
Interview.
it's not a transcript of the guilty plea.
Right, no, it's
Okay.
an interview.
Thank you.
It's an interview. That's what I was saying. It's
Okay.
an interview.
It's a transcript of an interview, which you don't assume you'll be using unless you have to refresh his
Impeach.
recollection or impeach him.
Right,
Okay.
that's what I was saying.
All right, no problem. How about this next thing labeled recording?
And let me just say, I don't know what Mr. Arnold's going to testify to or not testify to. To the extent that the state is ever planning on just playing I understand targeted impeachment, but and if I've fallen short of expectations, I apologize, but I have not reviewed this transcript for any extraneous, irrelevant,
Okay.
prejudicial.
And yeah,
things.
and thank you. Y'all don't intend to wholesale use that. If you did, that would be a problem, needs to be targeted. So yeah, just regular old trial evidence. Okay, thank you. All right, and this next thing, which is maybe some sort of a musical recording.
Oh gosh, another one.
Interview itself.
Ah, okay. I opened it up and it shows a musical note.
Oh,
I guess
no.
that's just my media player. Okay.
It's you.
And then this last thing is a picture.
Photograph, yes.
Any issues on this one?
Definitely, Sarah. I heard that too. I was wondering what that was.
No? Okay, moving on to Officer Munson then. Looks like there's another set of crime scene pictures, maybe. And a crime scene report. Couple of crime scene reports. Any issues on those?
Don't anticipate any issues with the crime scene photos.
Okay, thank you. All right, moving on to Jennings Kilgore. We're almost to the bottom of this grouping of 30.
Oh, wow.
This seems to be a ballistics expert.
NIBIN expert.
A what expert?
NIBIN, National
Okay.
Institute
What does that
of
mean?
Ballistics.
Okay.
Integration.
He is a ballistics expert with a
Ni-
particular.
NIBIN is different.
It's a big time one, right?
It's the one right before. It's not the actual firearms examiner. So it's a step before. It's a comparison to see if if these have the same characteristics.
All right, anyway, anybody have an issue with the evidence that's going to come in with this person?
I'm sorry, what is this?
What is this?
This is under, I'm trying to find out specifically where it's under the NIBIN reports. I don't know if I'm pronouncing that right. NIBIN charts. There's a document labeled Operation Planters
Okay.
NIBIN chart.
Okay, can't open that one either, but.
Yes, and that's a summary of
Okay.
NIBIN matches that were.
I'm having trouble seeing it in detail, but
Yeah, maybe because the black on the blue is a little hard to read. And we're all old and have old eyes.
I take offense to that.
So is the question
We're old
just
because
kind
we're
of like, what does
waiting
that
for
say?
you, Judge
Yeah,
Whitaker.
what is that?
So those are
Stop laughing.
the chart with the black on the blue. That one is showing that there were 5 shell casings from a particular scene. The black on the blue is the address.
Okay.
The red lines are matches to other addresses where shell casings consistent with the firearms at the previous address were found.
Okay.
And there was, I think that we served in discovery, but I don't think we included in this list of exhibits. There is also an ATF NIBIN examiner that we didn't have in here that they also examined some of these shell casings from different sites. Both Kilgore at the Atlanta Police Department and ATF were all working in conjunction with one another. So
Okay.
there is one more person that we'll be adding to that, but we'll let them know well before we.
All right, well, if they're gonna say the same thing, we don't need them both.
We won't. We won't. We won't
Why-
have.
All right.
Why are they
so
still
with
getting
regard
witnesses?
To this particular, this kind of chart, I guess, now that you know what it is there an objection?
I have one. Oh. Well, here's the problem, Your Honor. And before you were involved in this case, a lot of these prior incidents were Detective Dennis took the stand and the state brought out an easel and they wrote down all these different case numbers and they went through them real quick.
Okay.
On January 26th, 2015, there was a shooting at 841 Smith Street. I'm just making that
Yeah.
up. Okay. And in this, and as a gang investigator, I determined that that was part of this beef. Okay. We for a lot of these incidents, we have not heard from any witnesses that collected shell casings. There's been no chain of evidence. There's been no testimony about the collection of evidence.
Okay.
So this is just like coming in without any basis or any foundation, and it would all be hearsay.
All right, is
And
he,
violate the Confrontation Clause as
okay,
well.
is he gonna be testifying that he received the shell casings from each of these and did the exams, or that other person from ATF that you mentioned, or how is this gonna get used?
When shell casings are collected, the first person that does that comparison is either Kilgore at APD or they're taken down to ATF to do that comparison. What Kilgore or the ATF NIBIN person would say is this shell casing here was consistent with or had the same general class characteristics as this shell casing over here that was found at this scene and produce what we call a hit.
Right, so is Kilgore gonna be able to testify that for each of those blue boxes, he did an examination or comparison, and that's what he came up with?
Yes, for everyone that we have a match for, either Kilgore or ATF, or Kilgore or ATF did that initial NIBIN comparison. I'm not sure what the objection is. If we're not gonna have him talking about something somebody else did. If that's.
Okay, so I think one of the objections is that thus far, we have not heard shell casings were collected from this firearm scene and provided to Kilgore, and then Kilgore obviously would say, yeah, I got them and I did this evaluation. Is that all of that foundation is gonna have been laid in evidence by the time he gets here to testify to this?
Yes, that's why we have the crime scene technicians coming up, talking about what they collected.
So it sounds like by the time we get to this, that will have been done.
Be a two-way connection though. It can't just be, we collected, I'm using an example. We collected, certainly we've had the crime scene, or we will have had the crime scene technician, I believe, from the January 10th incident. So we'll know what was collected, and it was sent to Kilgore, and it was sent to Nibin, and we get that. But if they're going to say, well, it matches another crime scene,
Hey, Jason, you good? Okay, I don't know what's going on, so I'm gonna pull it up, pull it up on my stream. Okay.
And then Kilgore is saying, I got them both in the regular course and I compared them. Here's my conclusion that there's going to be an objection that he can't testify about crime scene B.
And to make certain, looking at the witnesses that we had initially put up, what we can do is add the 10 witnesses from each of those crime scenes that are on this list to make certain that we have each of those links included as
Sounds
evidence.
like that's
Thank
gonna
you,
have to
Becky.
happen. Now, it does not need to be, I don't think, a whole as if this were the crime on trial.
It would just be,
It can just be, I'm a
I
crime
witness
scene
number
tech.
1 through 10 that I'm adding on. I collected
I
this
went
one.
to this crime scene at this date. I collected
Right.
this evidence. I gave it to whomever.
Right.
Which should take 10
minutes.
Okay. All right. She plans to now do all of that. Unless y'all want to stipulate that those bullets got to the crime lab in the normal course from whatever crime scene, which I don't see happening. So, okay. All right. So anything else with regard to Kilgore's, the evidence that would come in through Kilgore? All right. Then our witness number 30 on this list is Underwood. Is Underwood also a Nibin expert?
She's one of our and detectives and gang experts in this case.
Okay.
And she actually may have been the one, she was an ATF task force agent, and she also would have been instrumental in taking some of the evidence over to the task force versus APD's ballistics lab where Kilgore worked.
Okay.
To have it tested over there.
Okay. Any issues with her evidence?
Yes, because it's going to be repetitive. She is an APD officer. And she's going to be supposedly or potentially the same treadmill of information about YSL and if gang, and this is what the policy is of the City of Atlanta Police, why we qualify people in a gang, and we've heard it from Detective Belknap, Detective Gaither, Detective Dennis. They have 5 gang experts allegedly from the same exact, they work together.
Is this a gang expert?
That's what I
She
said.
may be a gang expert, but is she going to testify as a gang expert?
I don't anticipate getting into anything overlapping. And actually, we were
Miss Love don't know.
before
Ask
this
somebody else.
last conversation thinking of not calling her at all.
But okay, so she would be chain of custody only?
Some chain of custody. And at this point, I don't anticipate calling her as another expert. But as far as the gang experts are concerned, Your Honor, I just point out that what we've done is announce to the court and to each of the defendants that our gang experts would not be talking about overlapping pieces of information. Every expert was talking about a different point in time as to their knowledge. Detective Underwood had an earlier knowledge of this particular street gang than did Detective Dennis. Detective Belknap testified to a different slice of time.
Okay.
Detective Dennis and Gaither were 2 people who worked as partners during the same period of time. But when we are alleging that this is a street gang that has existed from 2012 up until 2022, during the time of this indictment and even after, and we have every step of the way had cross-examination questions and the rebuttal assertion that this is not a gang, this is just a music label, and none of what you see really amounts to what the state is saying. To have gang experts who have an expertise in particular cuts of time that the gang existed is not cumulative. And the very fact that some of what they say overlaps doesn't in any way make what they're testifying about so cumulative.
I understand. All right. So has this person already testified as a gang expert?
She's not. She's just been qualified as one.
Okay. So you do not anticipate having her testify in her gang expertise role just as custodian of whatever this evidence and getting it from one place to another then. Is that right?
At this point, like we said, at first we were, and then we were like,
all right. And I would think that if for whatever reason you decide that's something you think you need to do, let's address that, because I don't think we need to hear, and I hear you saying we haven't heard the same thing, but we don't certainly moving forward need to hear the same thing. So, okay, that's clear. Thank you.
Your Honor, as the state is announcing that she's just going to be, Investigator Underwood is just going to be a kind of custodian of or transferring evidence from one place to another, I assume that the operation planner's NIBIN chart and the operation planner's NIBIN leads new chart will not be introduced through her?
Well, none of it's the same or substantially similar to what will be introduced through Kilgore.
I agree. I just noticed that in the folder.
Yeah, I mean, they do. Again, I don't know why, but I can't open a lot of these on this computer. But is that the same thing, or is that something
I
different?
don't think so, but I don't know for sure.
Picture showing like a flow chart involving the information that Kilgore has.
Generally the same?
It's all the same information. It's just presented.
It's more colorful?
Yes.
I mean, pick one or the other. Okay. All right. Is it easier to read than the other one?
It is.
Okay. Well, you can always switch the witnesses that you were going to use that for. But yeah, we don't want to see it twice. But okay. All right. That gets us through the our first 30 bucket.
We haven't done Mr. Sprinkle.
Well, yes, other than Mr. Sprinkle that everybody wanted to come back to. trying to just look back through at things we need to revisit or visit for the first time. Okay, so I think this is a good place for us to stop today. And then, you know, tomorrow, other than the potential hearsay and CAD reports, which we can take up, we can either move to the next 30 and do the same thing with regard to them, because they're going to have to be done at some point when the jury is out. Or y'all don't seem to want to reach the wiretap stuff yet, but as quickly as y'all can specifically identify that and get it
Because
to
Ms.
the
Love
defense,
hasn't
then
done it
we
yet.
can get to that. I think it'll be easier once they actually have targeted information about that. Yes, sir.
Know why
The screen
necessarily,
crashed,
but the
so I
state
jumped up.
specifically identified.
Oh, no, it's okay.
As they've
Did
stated,
it?
which is I
Yeah,
believe 13 or
it
14.
crashed. It went to just
I've
your
reviewed
picture.
those.
Okay,
Oh,
so tomorrow we can
I was trying to go
tackle those.
remote. Driving.
Everyone,
That's okay. I got it.
other people,
She's wrapping up.
not in a. I'll just say it affects.
Alerting
The
everyone.
DWC get RICO'd.
I'm alerting everyone that it affects more than just my client.
Okay, so everyone might want to.
That's what y'all's super chats go to, you know, so we can bail them out if we need to.
Before tomorrow. Okay, anything anybody needs to put on the record, make suggestions about for how to be efficient tomorrow, anything like that?
Your Honor, it's State's Exhibit number 55W, which would target the child with the hand signals.
Okay,
If you can, it's 55W has been shown to the jury.
would it be easy for somebody to pull it up on screen for me? And is this just a still photo or is this a video?
A short video.
Okay,
It was played for the jury.
all right. Is Mr. Kokomo going to play that for us, or is he, I don't see him anymore. I think the state's going to try to find it.
Didn't she just say they were done for the day? Now they're looking for something to play.
Yesterday, I just don't remember that, but it's one that was played months ago. Yeah, you come outside the house.
Okay.
I have another matter while the state is
All right.
helping us. Can I just tell you a case?
Mhm.
Okay, so I believe that my concern about when it's dealing with the RICO conspiracy in Brutin, and then the person in custody is giving a statement, confrontation clause statement, talking about the enterprise, let's say.
Okay.
I have found that my argument has been rejected. And this is the 11th Circuit, United States versus Espinosa, ESPINOZA. It's 635 Fed FED period APPX 739. It's in Division B as in Barry. And it's 11th Circuit 2015. And the 11th Circuit found that we reject the defendant's argument that because the confessional statements may be proof that a RICO enterprise existed, which is a necessary element of the RICO conspiracy charge against both defendants, the statements trigger a confrontation right under Brutin. If the defendants were correct, then any incriminating statement made by one non-testifying co-conspirator would be inadmissible against the other, whether or not the statement facially incriminated the other co-defendant. Brutin's narrow exception to the general rule of admissibility does not extend this far. That's what I found.
All right.
So it's only triggers what we were saying earlier, Mr. Stillwell, Mr. Williams, but I was saying YSL or the
Right.
crew, and I cannot find a case that supports that.
All right, I appreciate you bringing that to the court's attention. Every attorney has a duty to be candid with the court, even if the case law does not favor the argument they wish to make. And so I appreciate that, because I have to say, unfortunately, everybody doesn't do that. So thank you for doing that. Okay, do we have this ready to play? Oh, okay.
Haven't we already seen this? The one where he pulls out the gun and he gives the gun to the little kid. Yeah, this is the one I've seen. See? Do we have to watch the same clips twice? And then he hands the gun to the little boy.
Yeah, that's actually the one I was thinking about. I mean, that child starts doing all that stuff unprompted and then maybe gets encouraged to do a little bit more. But I don't think that that shows the same thing as the other piece of evidence that we were talking about. So thanks. but
More
my
body
ruling
sharing,
stands on
please.
that.
Can we have a continuing objection if I need?
You may. All right, I'll see everybody at 9 in the morning.
Judge,
Yes.
one thing we did reserve, if you recall, waiting for the order from Judge Glanville on witness number 26, that's Dennis, particularly number 74. We can deal with that tomorrow easily,
Okay.
though.
Great. Dennis, number 74. Mr. Harvey, was that one of the lyrics issues or was that a different item?
Well, it's lyrics, but it's a video.
Okay,
Thank you.
thank you.
You don't have to in court cases. It's a lot of states do, but they don't have to. So 9 a.m. tomorrow morning, which means the state will be there about 10:30. I'm kidding. Okay, and they went to the state of Georgia seal. So she made the state, wow, and then they wiped it off quick. Okay, well, I hear you. Well, she made the state do some work today. Of course, you know, they did it right there. They didn't like do work and then bring the work to court. I'm going to have to go and watch that that Supreme Court address from Mr. Steele. You guys said it was really good. I'm going to have to pull it up. You guys said it was amazing. But the 3 people that said it was amazing said that they were biased. Hey, Gemini, how are you, hon? It's good to see you. So what do you guys think about today? The prosecution was, again, it seems like they were unprepared, showing the same clips again. They have some court-ordered training to get done. They always have homework or training or something. That doesn't mean they're going to do it. Well, let's see if we have any super chats or anything to read out. Looks like he's read everything, which is fantastic. I appreciate you guys' support always of the channel. You guys are an amazing support. New member DC, welcome to the channel. Let us know if you want to get into the members only Discord. That is one of the many perks of being a member. Imagine spending all those years and money for law school to have to redo law school. I know, absolutely. Oh. I was in and out. That makes my head spin. You almost have to take a break. I think it's why, we have a hard time, but I think that's why Judge Whitaker takes the break she takes. Can you imagine being the judge in this case and having to stare with a straight face and not go, oh my gosh, love, you're driving me nuts, but having to stare at her with a straight face. So I think that's why they take convenience breaks so much. So I kind of get it. She goes to her office and screams and maybe rips a little chunk of hair out so she knows she's still alive. I was trying to go remote, but I guess I need to practice another time. That's okay, Jason. No worries. We got it. The court is over till 9 a.m. tomorrow morning. We're wrapping up now. Thank you guys for joining us. Thanks for being a part of the best live chat on the internet. We really appreciate it. And we'll see you guys tomorrow at 8:30 a.m. Unless Jason says differently, but make sure you have all the notifications turned on so you will get a notification. Yep, 8:30. I kind of figured. I know him a little bit by now. But make sure you have all your notifications turned on so you'll get notifications. And we will see you guys tomorrow morning, okay? Bye, guys. Be blessed.